go over to Rumble, people.
Now just take a 5-minute recess, which is basically be a bathroom break, and we will have
I gotta
looks like
take one.
25 minutes before the lunch break.
All right, people.
Yes,
I'm
Judge.
ending it on
Thank you.
I'm ending it on YouTube. Going over to Rumble. You know where to go, people. 5, 3, 2, over to Rumble now, and remove it. Oh yeah, remove. Here we go. We're on Rumble, Robert. Okay, now we're way behind, by the way. So let me see where we are. If I go live, yeah, no, Pattis is good. Pattis has got balls because I thought she was going to sanction him or threaten sanctions the third time he did it because it was obvious what he was doing. That's an article about the trial that I might bring up afterwards. Robert, you're still there?
I'm still here.
Okay, good. Where is my feed? It's right here. The feed is right here. Sorry, not my feed, the feed. Do I click live and take a chance? We're well behind. Here, I'll skip right ahead to...
Yeah, just skip to whoever a witness is on the stand.
Robert, I'm going to go to the little boys' room. For anybody who's wondering how I've held in pee for 2.5 hours. Okay, so here we don't hear anything. Okay.
I said after...
Okay, hold on.
Is in the...
Wait, here we go. Okay. We're not yet back to... How far behind are we? Oh, 30 minutes behind. Okay, but then there's a lot of.
May we approach this? What jury comes in just on a housekeeping issue?
Sure, they're going to be in any second, but okay.
By the way, notice their obsession with not allowing Alex Jones to defend himself in court, or that they're threatening him with contempt. We're holding you in contempt if you talk about anything we don't allow you to talk about. It shows what a show trial it is, and that's your classic example of a show trial.
Welcome back.
Okay, Robert, you're going to man it for 30 seconds.
Yeah.
Some of you have water now. Yeah, sure.
Notice, by the way, the disparity of
So I'm watching
presentation
you with particular interest
with the
because
judge,
there's two
with the
types
jury.
of juries.
Judges
who
love
take
to
the same
ingratiate
seats every
themselves with
time,
the
or
jury.
those who mix up a little bit. The lawyers know this,
Pleasant,
so I was sort of
sociable, and
wondering.
friendly, and the
I think I
leader.
have you guys figured out. So
It's very
let
rarely
the
who they
record
really
reflect that the entire jury panel is in the jury box. We're just
And
about
this
to
jury is
start
made
the
up of
evidence.
only six.
We're only going to get
There's
maybe
4
15
alternates
minutes in
present, but it's
before
only a
our required
6-person
1
jury that
to
will decide the
our lunch break. But what we'll do at this point is we will hand out the notepads, Mr. Ferraro, and the utensils for anyone who's interested. If you're undecided, you could take one and not use it. You'll let Mr. Ferraro know. The only thing is, please make sure that you write your name on the outside cover. And as I said, after every break, every recess, end of the day, Mr. Ferraro will get them, secure them, and no one will look at your notepads. And just take a moment when you get your notepad, if you're taking one, to please write your name on the cover so we don't have any issues redistributing them. All right, you may call your first witness, counsel. Oh. You may call your first witness.
Thank you, Your Honor. The plaintiff's call Bill Oldenburg.
Very well.
All right. What did I miss?
Good afternoon, sir. Just watch your step.
Nothing.
Make yourself as comfortable as you can.
Who's the witness?
Bill Oldenburger's, but I don't recognize him. No idea. Probably some, if they go with the Texas script, it'll be somebody who reported on the scene.
Take your name, spell your last name, for the record, and the town in which you live.
Sure. My name is William Aldenberg, Aldenberg, and I live in Sturbridge, Massachusetts.
Thank you.
All right, sir, I see you brought your own water, otherwise I would offer, you could always refill if you need, there should be. Is there a picture down there?
Yes, Your Honor.
Yeah. So
Thank
you help
you.
yourself at any time, and you may inquire whenever you're ready, counsel.
Thank you, Your Honor, and good afternoon, Bill.
Good afternoon.
Bill, Bill, I just want to orient the jury. Am I correct that on December 14th, 2012, you were a member of the FBI SWAT team in Connecticut that responded to the San Diego school?
The FBI agent.
And you're also a
Law
plaintiff in this
enforcement
case?
response.
Okay. Bill, why don't we start by having you
Now, here
tell
again,
the jury a little
how
bit
does this
about
relate to damages?
yourself? And I should also say, you're not
Damage his
here
reputation?
in your capacity as an FBI agent.
He's not a
correct?
reputation
No,
expert.
to clarify, people keep saying I'm retired. I'm not retired.
You're not retired.
No, sir.
Right.
But I'm here in my personal capacity, but I am an FBI agent. I'm here in my personal capacity.
Okay. And I just wanted to make that clear. So please, would you please tell the jury a little bit about yourself, both your personal background and your professional background?
Yes, sir.
Pause.
My name is Bill
This is-
Oldenburg. I currently
on a
work
second.
for the FBI.
Still can't figure out how to pop chat. I don't think I can raise chat in Rumble, which is very frustrating, but we're going to resolve that. Okay, sorry, Robert, go ahead.
Just that this is really not a good way to open a direct examination. So, and you see this in state courts. In some state, and particularly when you're the favored side, you get away with asking questions that your first-year law professor, as a first-year law student doing mock trial or trial practice, would tell you not to do, would fail you for doing. You're like kind of like this, right? So when he starts over the leading question, you're not allowed to lead your own witness. It says, weren't you this person at this time in this position? You know, it's like, what? Now, I guess he's trying to do that to tell the jury quickly who he is, but then he gets wrong that the guy's retired. The personal capacity issue is actually a giveaway that the guy's there on because they probably could not get an enforceable subpoena against the FBI. This is because under TUI principles, a U.S. Supreme Court case, the government, if they're not a party to a case, is almost impossible to use judicial process to force to testify in a case, which is ridiculous to me. But Supreme Court basically carved out an exception for them. So he's not here on the FBI's dime or FBI's time. He wants to emphasize here personally, but that suggests a personal motivation, a personal prejudice even. So I don't know if I were him as a witness and if I prepped him as a witness, I would not have had that be the first thing the guy says.
Now, is he a witness or is he one of the plaintiffs?
He's just a witness. To my knowledge, he's no connection to that. And so but the other thing is these kind of, hey man, will you just tell us why you're here? That's where a lot of ordinary people would like to have a question asked, but that's not a proper question. Who's your name? Well, you go off and you establish the foundation. What's your name? Where do you work? How long have you worked there? What kind of work do you do there? What are you trained to do? Were you employed there on X date? What happened on X date? Or were you tasked to a particular place? So on and so forth. Rather than this kind of, hey, I mean, that kind of informality is generally disfavored in court because it invites what they call narrative, and you're not supposed to be witness storytelling. You're just supposed to be answering questions.
So let's see what this guy's going to testify on.
I grew up in north of Boston in a town called Linfield.
Because I'm having a hard time hearing the witness.
I grew up in a town called Linfield, north of Boston.
Now pause.
Accent.
I went to Norwich.
Now, for those people out there watching that have heard us talk about trials before, how do you know this guy is a professional witness?
Looking at the jury. Looking at the jury automatically without, no prompt, unless he's been prepped. But
right. And I get into debates with other lawyers about whether a witness should look at the jury. And my counter, and I was like, I get it, it depends on the witness, their ability to communicate naturally and the rest. But Amber Heard did it in kind of a weird way, but that's because of Amber Heard. I don't know if there's a way to avoid that. My counter has always been, if looking at the jury is a bad idea, why does every professional law enforcement witness do it as a natural habit and custom? Because they think at least it works. That it leads to personal engagement and increased level of trust and confidence because of the eye contact. It also allows the witness to get a certain emotional and other observers, jury consultants, etc., to get a certain vibe of where the jury's mindset is, etc. But what this guy really is a professional witness, likely here to tell the dramatic trauma of Sandy Hook on that day, which once again doesn't clearly correspond to these plaintiffs' damages?
University, graduated in 91, degree in criminal justice, was commissioned in the Army Reserve. Spent 14 years in the Army Reserve as an infantry officer. In 1998, went to the police academy and became a police officer in my hometown. And in 2002, July 2002, I went to the FBI Academy at Quantico, Virginia, and became an FBI agent. I am married. My wife and I have been married for 24 years, and I have 3 children. One son who's in graduate school, a daughter that's in college, and my youngest is in 7th grade.
What in the world does this have to do with it?
I'm trying to make him personable, I guess, but it's
patently irrelevant and immaterial, and it's why judges don't like these open-ended questions. The witness is not there to just tell you a story. Now, you can argue with whether that's the way the courtroom should or shouldn't be, but when they say he's narrating, Judge, that this is precisely what they're saying is not allowed under the rules. So the very first question, very first set of answers, in violation of the rules. Of course, the court is magically mute because it's the plaintiffs.
Just want to hear where he's going with this. What's he there to testify on? He's there in his personal capacity, but he's an FBI agent or FBI law enforcement.
Bill, I can see that just taking the stand is emotional for you today.
I would object.
You can take a break at any time that you'd like.
Good, thank you.
Thank you.
You've testified many times as an FBI agent in the past, right?
Well, then I could testify in multiple trials.
Pause.
Multiple grand juries, state.
Professional witness.
So he's known about this for years. He's a professional witness. He's here in his personal capacity, so he's personally committed to it. It's been 10 years since thereabouts, since Sandy Hook, and he's already got the tears ready to go. Do you naturally believe him or not believe him when you know he's a professional witness who's testified so many times he can't care to count, and he's already crying as soon as he starts talking?
But Robert, I mean, are we black-pilled? Are we cynical? Or does a reasonable, impartial observer have this response? Because to me, it's a no-brainer.
That I don't know. But it tells you where the plaintiffs are going. Cry, 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 cry. Get mad, get mad, get mad, get mad. Cry, 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 cry. Get mad, get mad, get mad, get mad.
Trials, things like that.
But you've never testified in a setting like this?
No, not in my personal capacity, no, sir.
How long have you been married, Bill?
24 years.
Bill.
Pause.
Said you
Hold on.
joined the FBI in 2000.
Go for it.
That's a patent violation. The rules almost universally require you only refer to a witness by their last name. For this
Why would he be so cordial with him? Are they best friends?
I mean, unless this guy's the plaintiff, maybe he's the maybe he's the FBI plaintiff. I thought it was an ex-FBI plaintiff. So maybe that's who he is. But we'll find out soon enough. I assumed he was a law enforcement guy there to introduce the Sandy Hook story, but maybe he's both. Maybe he's the plaintiff. I don't remember the name of the plaintiff. I don't remember the name of the FBI
before that.
Yes.
Okay.
Why did you decide to go into public service?
Like a lot of the guys say, like a lot of us say, ever since I was a kid, I wanted to be a police officer. And when I graduated in 91, there weren't a lot of police jobs there like there are today. And so I did some private eye work for a while and still couldn't get a police job. And so then I decided to go to law school. And I went to law school. I graduated law school in 98, just before I
So
went
he's
to
a
the police.
lawyer. So that's how he got
getting a law degree would help you to be able to get into
a law
police
degree.
I was hoping.
Okay.
So somehow this guy didn't qualify to get a cop's
And
job
have you
anywhere.
found your
It's a
your
law
career in
degree, and
public
now he
service
gets
fulfilling,
elevated to the
Bill?
FBI. This
Yeah.
is why
Tell
our
me about
FBI
that.
is so pitiful. Too many lawyers.
I've had the opportunity to work a number of investigations over my career and wide ranging.
The way he's crying so often, he must be the
gang
plaintiff.
cases in
My guess.
Hartford for
No, I'm gonna
several
go
years,
just double check here.
drug cases. I've had a number of successful public corruption cases and civil rights investigations. And I've had a wide range of experience in the FBI that treated me very well.
Have you considered it part of your own personal mission to do what you could to protect the public?
Yes, yes, sir.
Is that why you tried to become a member of the FBI SWAT team?
Yes.
Can you tell the jury a little bit about that, what that entails?
Sure. 2004, I tried out for the FBI SWAT team in New Haven. You have to meet certain qualifications, physical qualifications, tactical, firearms. I made it through the training and been on the FBI New Haven team from 2004
Aldenberg is a
to
plaintiff.
2019.
He's one of the plaintiffs to the suit.
And as part of the FBI, and in particular as part of the SWAT team.
Yep.
So tactically, I think major mistake to start the trial with your least sympathetic plaintiff. Because this is someone who has no one, to my knowledge, who died. This is someone he's saying he suffered personal trauma from Alex Jones questioning Sandy Hook. Now, this exposes how problematic this case is. How is it that law enforcement now gets to sue you if you question what law enforcement did? People should understand what this precedent is meant to set up a precedent to sue anyone challenging elections. Can election officials now sue us if we say the election was stolen, or there was election fornication, that they stole the 2020 election or any other election? On these grounds, the answer is yes. As Norm Pattis said, Alex Jones first. Who next? Are we next? Second, can the FBI sue for anyone exposing FBI corruption? Talking about FBI corruption, discussing FBI corruption. Could J. Edgar Hoover have sued back into the day for the statements made about him on these grounds? Because to start off the case, this makes it clear how political it is and how tied to Trump it is. Because you're saying, look, you're the great FBI, and you've been defamed by Alex Jones. Right? Shut up, Alex Jones, forever, because he defamed the great FBI. By the way, to my knowledge, this guy's being allowed to sue, even though to my knowledge, Alex Jones never talked about him at all. And the parents' argument is derivative. Well, he made certain broad claims that somebody could infer was about us, that if they looked us up on the internet, they might find us. Only case in history that allowed that to be grounds for defamation. But this guy, that's not true of at all. This guy's suing on the grounds that Alex Jones questioned Sandy Hook. That means he questioned the FBI. I was in the FBI at Sandy Hook. Hence, I get to sue Alex Jones into oblivion. How insane is that?
Non-family member plaintiff.
Yeah.
Okay. Well, let's hear where he goes with this, saying that he was targeted by conspiracy theories. Why I've lost my window. Darn it! Where's the window? Hold on one second, people. I can't find. There it is. Okay.
Team, can you tell the jury a little bit about how you consider the importance of your own personal integrity and professionalism?
Yeah, this is ridiculous. This guy should have been the last witness. The last witness after you've done family members.
Yeah. I mean, obviously, as an FBI agent, you have a lot of responsibility as a SWAT team member.
What kind of question is this?
Taking on the responsibility.
Yeah.
Sorry, I was just trying to clarify.
Yeah, you're just trying to testify for him.
Tell the jury the role that integrity and professionalism plays both in your job as an FBI agent and as a SWAT team member.
See how they think the FBI is the greatest thing? They're bad timing for this. Now, they're hoping the jury's all a bunch of liberal Democrats who also worship the FBI.
Everything we do is
for the greater good,
based on our integrity.
Oh my God! Everything the FBI does is based on their integrity. They don't have any integrity. They're the definition of the lack of integrity. Everything but integrity
on the morning of
is
December
what FBI
14th,
stands for.
2012. Where were you first thing in the morning?
It was a SWAT training day. We had we were required to train so many days a month. That particular day was a SWAT training day. We were at the range in Middletown, Connecticut. So I would have gone from my residence directly to the range.
Okay. And when you say the range, you're talking about the firearms training range in Middletown?
Yes, sir.
Okay. And that's a state police facility that's also used by the FBI for that?
Yes.
Were other members of your team there that morning?
It's actually a Middletown police facility that's used by the FBI, sir.
Okay.
There were other, yes, so there are other FBI team members there that morning.
How many?
Altogether, I would say approximately 9, maybe 10.
Did you have a doctor who's also part of your team there?
Yes, we have a doctor assigned to the team. He's a doctor. He works for UConn Medical. As part of his job, he's assigned to tactical teams in the state.
And why does a doctor get assigned to the SWAT team?
The missions you do are extremely dangerous. They're, for example, you're arresting the most violent people or the most dangerous situations where something really bad could happen. So we have a doctor on the team in case something happens to one of us or to someone in the building or residence that we.
You mean unless you go all Waco on them?
It's very.
Unless you go all Ruby Ridge on them?
Gives you a sense of calmness to have an emergency doctor with you when you're hitting a door and people could possibly get shot or killed.
That morning, when you were at the range in Middletown, did your team receive a call to respond to a location?
The team doctor received a call from what I believe to be the medical.
Objection, speculation, hearsay.
We're not offering anything for the truth, Your Honor. We're offering you to. Thank you. You can continue.
The team doctor received a call from one of the paramedics from the state police team. It was something about.
This guy's going to cry every 5 seconds.
No, but he does look damaged.
He's an FBI. He's an FBI SWAT. And he can't stop to cry every 5 seconds.
Came into the team doctor.
He looks, Robert. He looks totally traumatized, or he looks broken, as I think most people would be.
Did you and your team understand that you were to go to Newtown?
Yes, basically there was some type of active shooter situation at a school in Newtown. And
I mean, I don't think he's acting. I think he looks totally broken.
My first thing was, well, where's Newtown? I didn't.
FBI 10 years SWAT team professional witness.
Bridgeport covers.
And 10 years later, you can't even talk about any of it without crying uncontrollably?
Paramedic needed.
I'm skeptical.
Rich to come to Newtown.
Rich is a doctor.
Yes. And
if that is the case, he probably should be in the FBI.
So at some point it was decided by my bosses or someone.
Objection, speculative, non-responsive at this point.
No,
Sustained.
It's okay. I'll take it step by step. I take it that as a result of that call, your team was dispatched down to the active shooter.
This is a leading
situation in Newtown.
Yeah.
Yes, sir.
Okay. Now, obviously, you weren't expecting that morning, correct?
No, sir.
Okay.
So we were expected to do training at the range.
Okay. For reasons that will become clear to the jury later, I want you to tell them about what your gear situation.
Narrative about the purpose of the question, Judge.
Sustained.
What was your gear situation that day, Bill?
So I had just received
His name is William
that day or
Aldenberg.
day or so before.
And you're supposed to use Mr. or Mrs. or Miss and their last name
a couple
only.
years.
Bill, it seems totally
However, often
improper.
because the material breaks down. So I had received a new vest. I was in the range house, which is picture a small room with multiple folding tables. I had my stuff laid out on the folding tables, and I was moving my equipment from my old vest to my new vest.
And when you say your equipment, would that include, for example, a patch identifying you as an FBI SWAT team member?
Yes, sir.
Would it include?
Objection leading, Judge.
It's preliminary to that. It's overruled.
Would it include communication systems like a radio?
Yes, sir.
What else?
Medical kit, ammo pouches, flashbang pouches, insignia, flashlight holder, different pouches for different things.
When you got the call to report down to the active shooter, how quickly did you guys get out of there?
Well, we probably left the range with it in less than 5 minutes, if not quicker.
Did you have a chance to move over all of your gear to your new vest?
No, I just grabbed my stuff and threw it in the trunk of my Bureau vehicle.
Now, do you recall whether you realized at the time you were initially called or some point thereafter that the location you were responding to was a school?
pretty certain that when we were leaving the range, I knew we were going to a school.
How did you all get down there?
We had a caravan of 4 or 5 vehicles, maybe 6.
Can we pull up exhibit 402, which has been admitted as full, please?
What's the number, sir?
402.
Thank you, sir.
Can you just blow that up, please, Pratik, if you wouldn't mind? Bill. It's a little bit hard to see here, but obviously you see that this map depicts the area from Meriden down to Newtown.
Yes.
Which route did you all travel to get down to Newtown that morning?
We left the range and got onto 691.
May I approach, Ron?
Now we're gonna have a sidebar.
Here.
Oh, sorry, this is not.
You know Newtown and Meriden?
Yes. 691, so we took 691 all the way to 84, and then 84
Through Waterbury?
I mean,
to
here,
Waterbury, yes, sir.
Okay.
given
to
that this is
exit-
just on damages,
well,
how much
Exit 10,
much
that's what it
does
was at
this
the time.
evidence
I don't know
relate
what
to
it is now.
You
damages?
can pull out, please, Pratik.
I mean, we'll see. It depends on where he's going.
Exit 10 off 84.
They want to show
Yes,
this.
sir.
I mean, the reason they're doing this is to dramatize the trauma of the incident of
How
Sandy
fast
Hook,
were you traveling to get down there?
Section relevance, Judge.
is how I take it. It's much more likely to be confusing and prejudicial than it is to be
Fast.
Did you have
material.
the sirens on?
Yes,
Lights?
yes.
When you got off the exit to Route 10, am I correct that at that point you were traveling to Sandy Hook Elementary School?
Sorry, sir?
You were traveling to Sandy Hook Elementary School?
Yes, sir.
Can we pull up exhibit number 401, please? Just if you could. You see the intersection there, Bill?
Yes,
You recognize this intersection?
yes.
What's this intersection of?
It's the, right there on the right is the access road to the school.
So, were you and your team coming this direction on Riverside Drive?
Yes.
I gotta
The
hop
school
off.
out this
I'll hop
way?
back on a
Yes, sir.
little bit.
What's this building here?
I believe it's the firehouse.
Pull up exhibit number 399, please. Thank you. If you're looking here, Bill, at exhibit 399, you recognize what's depicted here?
Yes, sir.
The building you just referred to as the firehouse, is that this building here in the upper left quadrant?
Yes,
Coming down to the access road here
yes,
to Sandy Hook School?
yes, sir.
Am I pointing here to the front of the school?
Yes.
Do you know what time you arrived?
Within 30 minutes of when they called it, we were there, I think within 30 to 40 minutes of the shooting.
As you approach the intersection of Riverside and Dickinson, the access drive up to the school, do you remember what you saw there?
As we were coming up the access road after we got our gear,
No. When you were approaching the intersection at the firehouse.
oh, I just remember there was a lot of cars and a lot of people.
And what did you all do next?
So there were 4 of us that pulled our vehicles in at the bottom of the access road by the firehouse.
And then what?
We geared up and we were waiting for directions on what to do. We were waiting to hear from our team leader. They instructed us to go up the access road to the school.
When you say you geared up, that would include, I take it, all the tactical equipment you had?
Yes, sir.
Rifles,
Yes, sir.
helmets,
Yes.
Kevlar vests?
Yes.
Did you have all the equipment you would normally have on you at that time?
There was stuff missing from my vest because I went with my old vest. I just grabbed the old vest and that's what I used.
Okay. And as you approached the school, tell me what happened next.
After we, the four of us
Just going to see how much is
FBI
left in
agents,
live
we-
testimony.
got our gear, we moved up the access road to meet the rest of the team. The rest of the team had pulled up to the parking lot.
Did you see any other law enforcement personnel that you recognized as you approached the school?
So at first, as excuse me, coming up the road, I see a uniformed trooper. And again, I wasn't really sure what was going on. I just know that whatever it was, there'd been a shooting. And I came up the road. There was a uniformed Connecticut trooper who was being led away by his coworker or someone else. And he was like in hysterics. And I'm like, what's going on? In our world, freaking.
Objection, that's non-responsive at this point, Judge.
It's not unresponsive, actually.
I would not have objected at this point.
That's unusual. Most law enforcement guys or law enforcement people are, don't get too emotional. And I saw that and I thought, what's going on? What's happened? And then we got past him and we got to the front of the school. And I saw another state trooper that I had worked cases with over the years.
Chad,
pretty well.
Who's wondering, it's witness William Aldenberg,
He saw me.
non-family plaintiff, FBI agent.
So what, Dave, what's going on? He says, oh, it's bad. Or something like, I'm paraphrasing, but it was bad.
Let
And
me stop you right here, Bill. Let me just stop you for a minute.
Sorry, Maddie, might this be a good time to break?
It's be a fine time, Judge. Thank you.
Okay, so we will take the luncheon recess now, 1 hour. It is imperative that you abide by all the rules of juror conduct that I told you. For those of you, I don't know if it's raining anymore, but for those of you who are entering outside of the building, make sure that you take the route that Mr. Ferraro tells you about, and you'll avoid, of course, anyone connected with this case or the media. Mr. Ferraro will collect your notepads and writing utensils, and he will give them back to you when we start again at 2 p.m. So we will take the recess.
What's amazing is you have a witness who's literally breaking down on the stand, and a judge who couldn't look less phased or less interested. I'll be called a bunch of names or whatever. I don't think this witness is faking. I don't think he's acting. I think he's in my humble assessment, a broken individual. And as anyone who went through his experience would be a broken individual. Yeah. So let me just make sure that we're up to speed here, and I'll just Okay, we're on break here. Okay. 17 minutes left. I might have to stop streaming at some point before the afternoon, but I'll bring this out. Bring this out. Bring this out. And then how do I get rid of this comment? Okay, there we go. Yeah, people, I believe that witness is genuinely a broken individual. Like, I'm not going to accuse this guy of crocodile tears the same way people accused Rittenhouse of crocodile tears when he had his breakdown on the stand. This looks sincere, and the man looks broken. And I think anybody who had gone through that would be traumatized for life, to put it mildly. Now, what's going on here in this trial, though? Strategically, I tend to agree with Barnes. Absolutely, I would, potentially not have started with this particular witness. It's very easy for everybody to play Monday morning quarterback and what they would have done, et cetera, et cetera. But starting with someone who's not going to be the most sympathetic of plaintiff witnesses, plaintiffs, are arguably the best strategy. The judge, totally unfazed as this witness is breaking down, she goes right into giving instructions to the jury. That's telling but irrelevant. this is the issue. I mean, the story, the facts they're difficult for people who didn't go through it directly to think about, to talk about. It's pure horror. That's the bottom line. Is the entire incident is pure horror. Now the question is this: who's responsible for it? And are they going after Jones for being are they treating Jones as though he was the perpetrator of this horror and not one of many commentators, analysts, whatever you want to call it? The entire thing is pure horror. And I've got family in the area. I got my brother, I have family that live in the area, or closer to at the time. Not so far removed from this. It's pure horror. The issue now is Alex Jones not being used as the scapegoat? Is he being used as the whipping post for the horror that was this thing? He said, look, we'll get into the evidence in as much as they're ever going to get into it, but they're not going to get into it. They're just going to be content with the judge saying Alex Jones said it was a hoax. They were crisis actors. It didn't happen. Whether or not those are contextually accurate summaries of 3 statements that Alex Jones made, he also repeatedly said it happened. It's horrific. It's going to be politically weaponized. Referred to the children that were murdered as angels, and they were repeatedly. And they're going to go after Alex Jones. I don't know. They went after the gun manufacturers or the manufacturer, Remington. They went after, I don't think they went after the school to any meaningful extent, whether or not the school had implemented proper safety protocol to ensure that something like this could not happen. Even if there is a depraved mind out there who wanted to do this. Did they go after Lance's family? I'm not actually sure offhand. I think some may have tried. Of course, judgment proof makes for no good defendants in a civil suit. They're going after Alex Jones as though he's responsible for what happened, as though he's responsible for the horror, as opposed to potentially, after the fact, having entertained certain things, entertained certain guests who said things that might, in fact, have been very hurtful, made certain statements that might have turned out to not be true. And what I think is clear, and it's what people might refer to the exploitation of the tragedy, is using this tragedy and all of its horror to silence someone who might have said outlandish, idiotic things after the fact, as though they were responsible for it having occurred in the first place. And that's what we see. That's what we see. It's not hyperbolic. The bottom line is it's not hyperbolic. They're bringing out an FBI agent as one of the plaintiffs, no family members involved, on the basis that he was defamed by statements that Alex Jones made questioning the incident. Let's operate on the basis he made certain statements which were factually incorrect. Now you're going to have an FBI agent who responded to the incident. He's already got a verdict in his favor. It has already been declared by a default verdict that an FBI agent, first responder, police, law enforcement, with no direct family involved, has a default verdict in his favor for intentional infliction of emotional distress, because call Alex Jones a shock jock. I know some people call him a prophet. A shock jock, prophet, conspiracy theorist, social media, internet commentator, questioned the response of law enforcement. And so now what's going to happen? If people question the response for law enforcement at Uvalde, if they say the response was negligent, if they say the response was arguably criminal, getting stand-down orders for over an hour, if people start saying that, is the chief from Uvalde going to now have the right to sue online commentators who say such things? This is not hyperbolic anymore. This is where it's at. I'm going to read some Rumble rants because I haven't read any of them. Viva, do you think Stephen James would break down on the stand like this? The point is that this guy breaks down like this decades later. He shouldn't be FBI SWAT. Okay, this is self-loathing lib. Viva, I don't know who Stephen James is, or Stephen L. James. I don't know if it's a typo. $5 Rumble rant. Do you think Stephen James would break down like this on the stand? The point is, if this guy will break down like this decades later, he shouldn't be FBI SWAT. I'll agree with you. So now what? He was, for whatever the reason, and maybe he is no longer because he simply cannot deal with it. I don't know how any human, like I had trouble dealing with law files that dealt with bad things. I don't actually know how people in law enforcement, first responders, deal with what they experience in the course of their profession. I don't know how humans can get over some of the trauma that humans endure. I don't know. So maybe he shouldn't have been an FBI SWAT. Okay, doesn't matter. Maybe he's more fragile than other people on FBI. Maybe he's too fragile and should never have been there. Okay, now what? I mean, that doesn't change anything. His response to me seems genuine, broken. But then the question is this: he is broken. He is traumatized. He is devastated from what he experienced that day. What role did Alex Jones have in the events of that day that broke this man? The answer is strictly none. He's going to say that Alex Jones went on air 3 hours later to commentate on it and argue as to how it was going to be weaponized politically to come after Second Amendment rights. Oh, that traumatized him. If the FBI agent comes out, or this guy, William, what's his name again? William Aldenberg. If Aldenberg comes out and says Jones's comments on this broke me and traumatized me, then I might have a much bigger issue with his testimony. The events of that day will horrify and traumatize this man for the rest of his life. What does Alex Jones have to do with that? He came out 3 hours later, and even if that clip that we saw is contextually accurate, they're going to use this to come after your Second Amendment rights. If that's what broke this man of that day and not the events of that day, I will then question his testimony. I took a bunch of pictures of previous Rumble rants, so let me get to them. There was Max from Zurich says, first post ever on Rumble. Max, are you from Zurich? Thank you very much. We got I'm Not Your Buddy Guy says, thank you for doing this stream, Viva. I hate these. Nobody can enjoy doing streams on these horrific incidents. They're traumatizing indirectly for people who were not directly involved, but for anybody who has the slightest degree of empathy. The issue here really is it's one where people have to dissociate the horror of the event from the actual issue at law. What responsibility does Alex Jones bear for the events of that day or for any damages he caused afterwards for his commentary, analysis, reporting, coverage, however you want to call it, of the events of that day? And what precedent will this set? And the precedent in Texas, what will it set? It's not going to stop here. Deplatforming, unpersoning Alex Jones didn't stop with Alex Jones. It went right to the president of the United States of America while he was sitting president. WCN2315 says, okay, broke up the laptop so I can holler. If you could put up headlines, why can't Def? And I think he might have hit send too quickly. Andres Burdens says, the masterclass from Barnes is worth the money. Thank you, gentlemen. Barbisa Arian, how's it going? 9/11. Americans died in the 2012 Benghazi attack. Ambassador Chris Stevens, Information Officer Sean Smith, and 2 CIA operatives, Glenn Doherty and Tyrone Woods, both former Navy SEALs, no justice. Sage Off Our Wins says, any chance we can get the Viva breakdown of the ruling in Antoniuk versus Bruin? Not right now, because I'm going to have to go look at it first. Self-Loathing Lib says, can I pop this chat out? Don't you own Rumble, Viva? They need to fix that, or you can't follow the wisdom of your viewers. I agree. And then Second Amendment or Die says, I'm a veteran. It makes me physically sick to watch this abomination of a trial. And the freedom haters will amplify this as much as possible in hopes that these will just be standard trials. Dawn189, the data that they are actively refused to look at, the science, medical, government, and leaked data doesn't count. Cool. I have personally emailed data to countless government and health experts. And I think that might have been on something else. Okay. Jules Verne 23 says, you don't get banned from every platform all at the same time because you said something questionable. You get banned for supporting Trump. Well, it was a known fact, or at least an admitted statement, that Alex Jones helped Trump get elected. His support certainly contributed to Trump's victory. And for that, some politicians will never forgive and will never forget. Okay, well, while we see what goes on when this comes back on, I wanted to bring up something the other day that I actually forgot to bring up. Speaking of Department of Justice, the Justice Department. No one's above the law, people. No one's above the law. You've got to read this because it's almost satirical in its drafting. This is the report. I tweeted this out the other day. This is the investigative summary from the Department of Justice, the Office of the Inspector General. Now, to bear in mind, who they're prosecuting, how hard they're prosecuting them, how hard they're sentencing them upon conviction. Just throwing that out there while we read this. Investigative Summary 22-103. There's no names in it, which is I actually prefer, at the very least for this type of analysis. Finding of misconduct by an assistant United States attorney for indecent exposure, sexual assault, and lack of candor. I hope that, that doesn't go in proper order. Sexual assault, indecent exposure, and at the very end, lack of candor, because that among the three accusations is by far the least important as far as I'm concerned. Department of Justice, Officer of the Inspector General, initiated this investigation upon the receipt of information from the Executive Office for the United States Attorney, alleging that an assistant United States attorney had exposed the AUSA's genitals while in a public place and had sexually assaulted a civilian while on a date. The OIG investigation found that the AUSA's genitals were exposed in public and that the AUSA forced the civilian's hand to touch the AUSA's genitals in violation of state law and federal regulations governing off-duty conduct. The OIG also found that the AUSA lacked candor in discussing this incident with the OIG. Seems like a slam dunk. This seems like more of a slam dunk than Michael Sussman's case. Criminal prosecution of the AUSA was declined. Yeah, we've come to the conclusion you broke state and federal law. We've declined to prosecute. It's not we've sentenced you to 10 years and it's too much. We've declined criminal prosecution. Thank you. Your request for criminal prosecution, notwithstanding the fact that we found you violated state and federal regulations governing off-duty conduct, criminal prosecution of the AUSA was declined. The OIG has completed its investigation and provided some support to the EOA, yada, 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 yada. Unless otherwise noted, the OIG applies the preponderance of the evidence standard in determining whether Department of Justice personnel have committed misconduct. Oh, so preponderance. So I presume then this is not exactly a criminal investigation. Preponderance. No, but I think in terms of bringing charges, it has to be, you have to be able to prove the crime. They found that he violated state and federal regulations governing off-duty conduct, but declined ever so politely to prosecute. Makes total sense. No one's above the law, except some people are more above the law than others, and others are more below the law than others. Kimba says, $25 Rumble rant. Rumble is the future for freedom. I agree. They're going to work out their glitches, people. I'm like literally texting people in real time. I want to be able to bring up comments. Like I want to be able to bring up a highlighted comment so I can see it in the chat. And I can't do that. And that frustrates me because that also makes it a little more difficult to engage and discuss. All right. What was the other thing that I was going to talk about? I'm going to pull up another article on the trial. We'll get the rundown. People were saying, "Can you give us a 30,000-foot overview?" And I took for granted everybody knows what's going on in this trial. There's 9,000 people watching. I think 8,000 know what's going on, and to the 1,000 who are new, welcome to Viva Fry. I am a Montreal litigator turned YouTuber turned Rumbler. 13 plus years of active practice, no ethics complaints, untarnished reputation, untarnished practice. In fact, the only ethics complaint I ever got was 2 years after my last file because of a Twitter tweet. Not in the practice. It was a request to investigate because someone online didn't like a tweet and thought that the responsible, appropriate, and judicious thing would be to file a complaint or request an investigation with the Bar Society, because that's how things are done these days. A political tweet about a prime minister, it hurt someone's feelings so much they thought the appropriate remedy is an ethics complaint to the Bar Society. Okay, this is a CT Insider, which I believe is Connecticut Insider. Let me see here. I think it is. On Alex Jones, some potential jurors in the Connecticut Sandy Hook damages trial say they couldn't be fair. What year is this from? What date is this from? August 18th. So it's a little outdated. August? September. Yeah, it's a month old. Attorneys question, because I wanted to go through the prospective jurors. I wanted to see if I can get a copy of the jury questionnaire to see what questions were on it, but I presume it's going to be the same types of questions that we see everywhere. You know, where do you get your media from? How do you feel about the government? Yada, yada, yada. Let's just see what this happens to say here. Attorneys questioned prospective jurors on Thursday over whether they could impartially determine how much Alex Jones should pay in damages to 8 Sandy Hook families and an FBI agent he defamed, because it's no longer allegedly. And the judge in the Texas case astutely pointed this out. No, this is not a claim for defamation. There's a default verdict for defamation. This is a judgment for defamation. Now it's just a question of how much you have to pay. So these are judicial facts in as much as they upset everybody. For several, the answer was no. How much Alex Jones should pay to 8? Okay. For several, the answer was no. That doesn't make sense. I know what he's about, one man said in Waterbury after answering a question from the family's attorneys. I know what he says. I don't think I would be fair. That is actually more insightful than many actual impartial jurors would be able to assess themselves. Just over a week after a Texas jury awarded 2 Sandy Hook parents $49.2 million in damages and compensation from Alex Jones, jury selection resumed Thursday in a similar trial in Waterbury to determine how much the InfoWars host should pay to a different set of families and the FBI agent whose testimony we're watching right now. Only one juror, a widow who is a grandmother, was picked on Thursday. It's expected to take weeks for 6 jurors and 4 alternates to be picked for the trial, which is scheduled to begin today. The trial will likely be as dramatic as the Texas court proceedings, which included heart-wrenching testimony, admonishments from the judge to Jones not to lie under oath. Gotta love the. It's almost like the judge was admonishing Alex Jones under oath, not to lie under oath, so that media could then report that he was admonished for lying under oath. And the possibility that his Connecticut and Texas attorneys could be sanctioned for inadvertently sharing medical records of the Sandy Hook parents who filed the Waterbury lawsuit to the plaintiff's attorneys. Jones, who was not in the courtroom Thursday, attempted to forestall the pleadings. He filed for bankruptcy, and then they said, we're going to proceed nonetheless. But I think they put a hold on that. Yada, yada. Jury selection restarted Thursday morning, despite the company arguing in a Wednesday night filing, bankruptcy proceedings should be stayed. Norm Pattis, attorney for Jones, commented that free speech systems is working against him. They are persisting in a course that's catastrophic to my defense, Pattis told the superior judge. Okay. He's concerned employees of the company will not be able to testify due to bankruptcy proceedings, but Bellis said that there had been no prohibition on employees for free speech systems participating in the trial. Okay, this is what we want to get to. 42 prospective. I think they're coming back. I think they're back here. Sorry, got distracted.
That's fine.
Your Honor, we have no objection here.
That's fine.
Thank you.
So they were talking about him referring to the witness by his first name, which was interesting. But
We all set to go?
it cut in. It cut in very
Did you take
quickly.
care of the button, the sticker on that one?
Yes, it was actually on her shirt, the sweater.
I didn't see it. Okay.
Yes,
Terrific.
no problem. And I have some with me.
Okay, chat, let me know if we can hear and see everything properly. I'm leaving that comment up on the bottom just to... Okay, let me see here. Chat, are we good? Everybody can see and hear in real time. Let me refresh and make sure. Underdog says I should contact Salty. I will contact Salty so they can show me how to post live Rumble rants. If it requires external software, I have some, so I think I could probably do that. Viva's ADD is terrible. How dare you mock my ADD? Audio is good? Okay, here we go. Good. I'm going to bring it back.
All right, welcome back. Take your regular seat or mix it up as you will.
Yes, I know all you out there and hated men can hear that. Welcome, Anna Merlin. I hope you're enjoying the trial.
And council stipulate that the entire panel has returned.
Yes.
Mr. Ferraro is redistributing the notepads. Sir, you may resume the stand. There you are. And of course, you remain under oath, as you know.
Sure.
It's funny, it cut in at what they were talking about an objection, and it had to do with referring to someone by their first
Thank you,
name.
Your Honor.
I'm going to see if probably won't happen again.
Bill, when we left off, you were just describing your approach to the school.
Yes.
Okay. And I think after you were describing seeing some of the troopers who were coming down from the school, you were about to talk about meeting up with the rest of your team members. Can you just continue from there, please?
Yes, sir. So, let's put the photo up.
You want the photo up? Yes. Let's put 399 back up, please.
Once we got to the,
And just hold on one second, Bill. If you could just try and keep your voice up.
yes, sir.
He just did it
Once we-
again.
Say the same thing. I just want to make sure that Attorney Haddis and everyone can hear you.
Yes,
okay?
yes, Your Honor. So we made our way up through the access road to the front of the school. That's where I saw the officer from the state police that I've known from past investigation.
Okay.
He seemed to be, so I had a brief conversation with him, and then our team leader brought our team together in front of the school.
May I approach the screen? Thank you. Just to remind the jury, this here where I'm directing your attention, that's the front area of the school where you grouped up with your team leader and the rest of your team.
Yes, sir.
And when you gathered together, did you receive orders for what you and your team were to do next?
Yes, yes, sir. It was my understanding that we were going to assist the state police SWAT team with clearing the school.
And were you aware at that time whether the active shooter situation at that point was no longer ongoing?
Yes, sir. It's my understanding at that point. Yes, sir. The active shooter. Yes, it was done. It was over. Yes, sir.
Your Honor, may I have one moment, please?
Take your time.
So the question is, I mean, Pattis, Jones's attorney, can probably object to a lot of the questions he's asking of this witness because they're leading. The only question is, what good is it going to do? The judge will allow it. It'll make him look defensive. What any of this has to do with the damages against Alex
Thank you, Your Honor.
Jones to be determined.
Bill, I am going to
Bill, again.
going to ask you to describe. Let's pull up exhibit number 398, please. Now, what we're seeing here, Bill, is the
Is
school,
he
but
doing
from
it? Is he doing it
the
to try to
front
get a
entrance,
reaction
right?
out
Yes, sir.
of Pattis?
And so now we're looking in the other direction, and this is the front of the school, right?
Yes, sir.
And as I'm pointing at here, this is the covered front entryway to the school.
Yes, sir.
And can you just describe for the jury where you and your team were located as you were about to enter the school?
Do you want me to get the point? Do you want me? We're to the left of the front entrance, sir.
Here?
Yeah, left of the front entrance. Yeah.
The witness is saying "sir" and the lawyer saying "Bill." It's a curious dynamic. I'm just going to leave this
We show it to
Comment
the
on the
full
bottom.
5, please. This is the front entrance of the school.
Yes, sir.
On the left side of the photograph, adjacent to the front entrance, do you see vertical windows going up to the roof?
Yes, sir.
I'm just going to get this area here. You see that?
Yes, sir.
What area is that?
That's the first classroom.
Describe for the jury your entrance to the school, please.
Our team entered through that door, and we met the state police team in the lobby, is what I recall.
Can we pull up exhibit 406, please? And just zoom in on just the front entrance, please. That's fine. Bill, do you see
Why is he doing it?
window pane on the right side of the entrance shattered with a hole through it?
Yes, sir.
Was that the condition of that window when you arrived and prepared entry to the school?
Yes, sir.
Please describe the next action that you took.
Once we linked up with the state police team, our team leader told us that we were going to search one side of the school and the state police were going to search the other side of the school. We had some state police officers with our team. So one team was going to go to the right, one team was going to go to the left, and that we were looking for, any survivors, anyone hiding, things like that.
Okay. Can you zoom out of that photograph, please? And just zoom in on the right side of the photograph, if you wouldn't mind. Do you see, Bill, to the right, there's a hallway going back towards the rear of the school?
I think I just heard the lawyer say he did it again or he got it again.
And your team, which direction were you ordered to go in?
We went down that hallway to the right, down the right side, to the right.
At some point,
The other team
Pattis
went
is
to the
going to
left.
object for
And
relevance.
as you entered, can you pull out and zoom out of that, please?
Oh, Robert's back in
The
house.
area just beyond the front door, is that the lobby to the school?
Yes, sir.
As you entered
Is
the
that a door?
lobby,
Is that door
what
open?
did you see?
Is that one of those
Hey,
things that you
on
push on the door to
If you go
open
through
the door?
those,
Is that a
double
flag
doors there.
over to the right?
I mean, Robert,
This is why trials get boring.
the hallway goes to the left, and there were two
Lord have
victims.
mercy. I get there.
On the,
Now here again, judges allowing the plaintiff
on
to
the
present.
corner.
How does
They're at-
how much of
they're
this
sitting
at
in the
all
corner.
relate to damages?
Two adult
How-
females.
I mean, isn't this cumulative? What's called unduly
come to learn that
cumulative, unfairly prejudicial because it isn't
women
material.
Who are laying there with
and
the principal's on
induces
Hoxprong and the
it's-
school psychologist.
This horrible
Sherlock.
thing
Yeah, I
happened.
learned that.
Let's
within-
blame Alex Jones for
I
it.
learned that before. I think I left the school. I learned.
But your team was to go to the right.
Yes. But, yes.
To the right versus the left. That's where we're at in
You
this
had
trial.
Dr.
No
the
wonder
doctor
it's
with you,
scheduled
correct?
for 4 weeks.
Uh,
Plaintiffs are
Doctor-
unduly
The doctor
boring
was
and
with us. I just don't
objection,
know
Your
if he
Honor.
was
Plaintiffs are
helping
unduly
us.
boring.
He wouldn't help
taking
us
much
clear.
time.
He would be there to,
Plaintiffs counsel didn't
Assist,
practice trial advocacy
with
very well.
injuries and stuff. So he wouldn't have assisted with the clearing. But he certainly was, I could tell you, was in the school.
Did you just observe other EMTs in the school as you were there?
Now, later on, I saw at least two EMTs or firemen. I would think were Newtown firefighters in the hallway.
Can we pull up exhibit 415, please?
I'm trying to find a comment that I can just leave over the bottom so
just
we
zoom
don't
in on
show
the
the law and
diagram.
crime logo.
Just so I don't have that as a full exhibit, unless I missed something.
Why don't we take it down? I know it's agreed upon.
Well, can
Okay, we're gonna go with
Take
this.
your time.
Was not on the list read this morning.
I like this in the live chat, which people can get at vivabarneslaw.locals.com, but there's also a live chat. I'm listening to this at 1.75 times speed because I'd rather hear nails on a
You
chalkboard
recognize this to
than
be
hear this judge
the
speak.
layout of the,
His prosecution
of the
lawyer
school?
is insufferable. The saving grace is AJ's lawyer is
Yes, sir,
smooth
it
and
is.
likable.
And you see, indicated here is the patio in the lobby, right?
Yes, sir.
And
How
when
again
you
does this
came
relate
in
to
with your
damages?
team, Take that you came down this hallway to the right.
Yes.
Can you describe for the jury that process, please?
We went, it was
Imagine
There's a team
so
on the
they
right
get to put in
side
all this
that cleared those
context
rooms
that's
on the right.
really cumulative
There was
and
a team on the
prejudicial.
left side
Jones isn't
that
even
cleared the
allowed to
rooms
explain himself
on the
on
left. I recall being on that right side team as we went down the hallway.
And was this side of the hallway empty?
Yes.
Did you go through each room with your team searching for any survivors or anybody that might be hidden?
Yes, sir.
Well, we're just
And
getting
describe
to
to me
this.
how that process ended.
We're in a number of classrooms, and then I think the last room I remember being in was what I would call like a boiler room. Another agent, myself, were in this, like a maintenance or boiler room. And we were checking behind metal.
Has the FBI ever disclosed through FOIA all of their records on
metal
this, or did they not consider this an
Cabinet
FBI
doors or metal
operation?
doors that opened up into pipes and stuff.
Because the state of Connecticut hid a lot of
Did you
their
and your team
records.
satisfy yourselves that that
Which
this
is
side
what
of the school
triggered
was
all the
just essentially
conspiracy.
empty, that everybody evacuated?
I know that the people in charge determined that, yes, we had cleared that side.
Tell the jury what you did next.
We returned to the lobby, and then what I recall is that we went back out to the front of the school.
Continue.
So the
And then,
FBI SWAT team was
At
on
some point,
location.
it was determined.
Has he explained
Sorry.
whether they were there as
they had-
volunteers? Were they there as
either
law
found, like,
enforcement?
one-
He said they were
They
dispatched or
found
deployed
Like an adult
when they were
female or
once they
two
were
adult
having their training
females
session
alive, they were hiding
the same
somewhere.
day.
That's what I
But
recall.
what-
That they were
It's almost as if it's a coincidence they happen
in
to
an
be at
office or something.
that local
was
police
after-
station. Because I'm
not
just
when we
wondering,
had searched.
I didn't think it was protocol for
And,
the FBI to have jurisdiction
So
over a
they
local
determined that
criminal matter.
they wanted the whole process done again.
You see what I mean?
That these
It's a little odd that they're legally
staff
there.
members are,
Unless they're part of a
were
joint,
hiding, obviously
joint and they're
hiding
under the
for their lives,
jurisdiction of the
and,
local government.
um,
That's the part
it
that,
was determined that they
at least
wanted
I was
the whole
unaware of
place done
until
again.
him talking
So
now.
did you and your team have to re-enter the school at that time?
Yes, along with the state police team.
But it was
See, the way he
determined
says
your
that
team this
makes it
time would
sound
go
like the
to
FBI
the
was
left,
working
correct?
under the
Yes, sir.
state police. But that's very unusual
Can
protocol.
you pull out and focus in on the hallway to the left?
That means there should be FBI FOIA documents on this, and for whatever reason, maybe they exist and I just missed them over the years. But I was unaware that the FBI had a formal response to the change.
Just zoom out of this, please, particularly. Just on this area here, please. When you came into the school and entered the left, where did you go first?
So I was the first in what they call the stack. So I know I was first. And then there were two other guys, two other of my teammates with me when we entered the first classroom. Sorry. We entered that classroom through the door, the first classroom.
Now, does he explain issues about the doors not being locked? You probably unlocked. Probably he's going to
No,
skip.
I'm not going to ask you.
I mean, the problem is that this is all, like I said before, this is pure horror.
What you saw in that
What does
classroom
this
was
have to
very
do
real,
with Alex
wasn't it?
Jones?
Yes, sir.
Right. What does it have to do with damages related to Alex Jones, as opposed to damages related to Sandy
So
Hook, the
sorry.
event?
So sorry, these people have to listen. They have to listen to this, but
You know,
I saw.
Bill, stop.
Oh, man.
You
Sorry.
came through that first classroom, Bill.
Yes, sir.
Did you then enter the second classroom?
Stepped to the first classroom.
He's fully
Clearly-
turned his seat
And
to
then we
direct
went
right
through
at
the classrooms were divided by I guess, like a middle door. The two classrooms were attached by a middle door. We entered into the second classroom.
That was Vicky Soto's classroom?
I learned that after, yes.
You learned after that Miss Soto was killed where she was.
Objection leading, Judge.
No,
What did you, I'm sorry.
I know that.
Hang on a second, Bill. There was an objection. It's fine.
Robert, why does he keep saying Bill? It's like he's doing it to try to get a reaction out of Jones's
Did
attorney.
you observe Miss Soto where she laid in that classroom?
I observed a teacher who I learned later was Mrs. Soto. So, yes.
Without saying anything about. Do you remember anything about Miss Soto's telephone?
I mean, it's just certain things there's certain things I remember that day, like, it's probably like 6 or 7 of them. But I remember that next to the teacher, who I later learned was Mrs. Soto, I remember there was a phone. And I remember the phone, like I remember the phone was like lighting up, but I later learned from.
Objection, hearsay, non-responsive.
And what is it? This is
Yes, sir.
it's all
I
horrific.
couldn't,
It's about a show trial.
our senses
You
were,
get to plaintiffs, you get to put on all your emotional, traumatic evidence, even though it has no bearing on what is actually being
I
tried
don't
in
know,
the
I don't know
case.
what I heard. I just
In order
know
to
that what I
increase the
saw.
damages award against Jones, who's not allowed to even
It's
present any defenses to
pretty
the merits or contextualize
horrible.
what he did at all. So it's a classic definition of a Soviet-style, Stasi-style show trial.
Did you finish
That's
figuring
what
that
it is.
out?
And we're seeing it. And
It's just
what
once we went
offends me
through
is
two classrooms.
this makes the legal system look like the
we
caricature
cleared each room
its
down the
critics make
hallways.
of it, particularly the American criminal justice process. They
and,
say what it's about. It's
I know
about
there was one room that we
showmanship.
found.
It's
We didn't
about
find anything.
emotion.
Like,
It's
we
not
didn't find
about
anything
fact.
in any
It's
of the
not
other
about
classrooms.
evidence. It's not about
But we were in
law.
such a,
This is what the critics think when they
We were
think of
in such a
plaintiffs'
panic,
lawyers. They
or
think
at
of
least
them
I was thinking, I
exaggerating
just wouldn't look
damages
at it.
claims and et cetera. People
Well, look
still
at
misunderstand
everywhere.
what the McDonald's case was
just
all
couldn't
about.
find something.
Because this is the bad
Look at
stereotype of American law, and yet these judges are welcoming it
We saw
putting
some
it on
blood,
full
and then
display
later on, there
because
was
they hate Alex Jones.
down the hallway or in another classroom. I don't recall exactly, but later on, we were told that that was like one of the.
Objection, hearsay at that point, Judge.
Sustained.
Not offering for the truth of the matter, Your Honor.
Relevance matter.
Just off.
You just ask the next question.
Did you learn as a result of that one of the children
Leading,
had
Judge.
been previously found
Like,
and transported for medical attention?
at some point, I learned.
Attorney Gaddis, can you ask it in a non-meeting way?
Sure,
I'll give
Judge.
it credit,
What
Judge
was the
credit.
significance,
During the
Bill,
trial so far, she has
of
stuck
the
to the
fact
rules
that
of
you
evidence.
and your team found blood, but no body nearby?
I just either I assumed or
Except
later
the
on I
fact
learned that
To me, almost none of this
a child,
is relevant to a damages
Or-
trial.
a child or children were transported to the hospital, and that's what the blood was
Now,
from.
for a lot of
And
people
then
out there, this is the only time the Sandy Hook case has ever gone to court, to my knowledge.
maybe one of the
There never was a
first-
criminal case
the officers that were
prosecuted.
initially there had
The
tried to.
lawsuits against the school system in the states were all dismissed.
Claim it.
Attorney Gaddis, can I have a sideboard counsel? No, we need to put my glasses on. We don't want to-
identity henceforth. Okay, sorry.
Robert, so sidebars, technically, they should be public,
You
but
and your team and the state police.
they're not
team
supposed to
Well,
be
sidebars are supposed to
had
be
cleared the school.
out of the earshot of the jury, but transcribed.
You gathered
so they're
outside
part
the
of the
school
official
to wait
court
your next orders?
Yes, sir, we gathered out in the front of the school, but further down the end, and that's when
Now, it is horrifying
remember
what
seeing
they,
other
not only
members
the
of our
discovery,
team
but the
arriving.
way the bodies were
the
found.
guys who weren't.
Many of the bodies
guys
were
who
found
deployed from
stacked
other
up
locations and
in
other
inside
divisions
bathrooms,
were
inside the
arriving.
classrooms.
And
Now, and they hid that
our
for
team
years,
leader
which nobody understood why.
at some point told
I
us,
believe the reason was the nature of the deaths
and
exposed that
later
school
on, maybe an
safety
hour or
was
so
the
later,
thing
we
that
ended
was
up
really
going
missing.
to what they
In
would
other
call
words,
an
that is
emergency
because there was
operations
no
center.
place, no inside door they could lock.
Let me ask you, do
They
you
couldn't
recall?
lock the classroom door. They couldn't lock
Do
the
you
bathroom
recall
door inside the
approximately
classroom.
what time it may
There
have
was no
been
way
when
to
you
protect themselves from the
completed
shooter.
your work at the school and came out with your team?
I mean, we probably were in there. I mean, again, it's 10 years ago, so I would say it was probably an hour, maybe an hour and a half. Probably more like an hour.
Do you have any idea who Alex Jones was at that time?
No, sir.
Was what you saw in that school fake?
No. No, sir.
Was it synthetic?
No, sir. No, sir.
See any actors that day, Bill?
No.
This is crass examination to me.
Was children real?
It's awful.
And to be honest with you, here's how this.
Were
If
you
I
aware
was
that
a
at that
plaintiff's
very moment,
counsel, I
Alex
wouldn't do
Jones
it in
was
this
telling
way.
his audience of millions?
It's so open
that
and
what you had just
overt,
seen was
etc.
staged?
Objection, Judge Leading.
You do it subtle.
No.
You do it more indirect.
No, I
You
didn't
let the
know.
drama occur
Excuse me,
naturally,
strike.
not try to
I'll strike
superimpose
it,
it.
the jury will disregard it, sir, when I sustain an objection.
Yes, sir. I'm sorry. Yes, sir.
For the next part. Nope.
Yes, sir.
No, it's almost.
Did you know that Alex Jones was on the air at that time?
No, sir.
Objection. Relevance.
Let him answer. He didn't know at the time. He didn't know. How is he he's gonna claim damages from something he didn't know at the time? But this
Pull
is
up exhibit 120, page 6, please.
It's all- it's all-
212.
it's almost like he's
2012 chart.
badgering his own witness to.
This is already in, Judge.
I'm going to turn the volume down of the feed or pause it when. I'll tell. I don't. This guy's not faking people. This guy is a broken human.
Infowars.com website, the year 2012. Do you see the year totals
I mean,
down
my
there,
concern
Bill?
would be if this trauma affects you, and I get it's
Yes, sir.
unique trauma, but remember, he's an FBI SWAT team guy.
Do you know that Mr. Jones's
Should
website that year?
someone who responds to trauma in this way still be on the FBI SWAT team?
Is he still? The question is he still? Maybe he's not.
He claimed he was not retired.
Yeah,
I
but
thought
he
he was
might-
an ex-agent.
He might
Maybe
be
he's
doing
removed
something.
from that, but it's
Yeah.
like if you're someone that can't handle horrific violence, you really should not be on the SWAT team
I don't think
because
there's
you
any-
have to respond in live time, typically to seeing that. That's part of the duty. You need to be someone who's able to control and if 10 years later you can't handle seeing the after effects of a traumatic event, then you probably shouldn't have been on the SWAT team to begin with.
Yeah, I'm sure most people agree with that. This guy's broken, and I don't think it's. I don't think he's acting. It's just whether or not he should be doing whatever he is doing, or if he's not doing it now. But
Yeah,
that-
I conclude one of two. Either he's someone that so is unable to control emotion that he was in the wrong job, or if that isn't the explanation, the alternative explanation is that this is a prepared reaction. I agree with you that he seems to be it seems to be beyond his control, which tells me he never should have been in the FBI SWAT team. Just to, again, understand that a lot of people would react the way he does. The point of being in the FBI SWAT team is that you're one of those people who don't react, that you're able to cabin this and contain it. You don't want someone it's like being in the military out on the battlefield. If you see trauma and can't handle it, you shouldn't be a soldier. Same with the SWAT team here. But again, almost all of this has nothing to do with this case.
No, it's rehashing the trauma for the jury and for the plaintiffs, and
it's the classic definition for people out there. There's a kind of evidence called Rule 403 in the Federal Rules of Evidence. There's versions of it, all the states, analogs, that if evidence is first evidence has to be relevant, means it has to be material to the decision that the jury's being asked to make. And even if it is relevant, it still should not be admitted if it's either unduly cumulative, unduly confusing, or unfairly prejudicial. And what that means is you're sort of weighing it. You're saying, what's going to be the impact of this evidence? Is this evidence more likely to confuse, prejudice? And what prejudice means, it means the jury decides a fact question related to the case that's not based on grounds they shouldn't. And here, what's cumulative about this, what's confusing about this, what's prejudicial about this is it invites the jury to make a determination based on the trauma he experienced at Sandy Hook rather than on the statements that Alex Jones made. Mm-hmm. And I think that the quantum that's unfairly prejudicial and unduly confusing, and at some point, given the length of this, just to date, the length of this testimony, arguably cumulative as well, way outweighs whatever probative value it has, which I see as marginal or non-existent. Because again, the jury's just being asked to determine, after he heard Alex Jones's statements, how did that emotionally and reputationally impact him? Not what happened at Sandy Hook. And I get that there might be some link between what happened at what he experienced at Sandy Hook and what he experienced from Jones's statements, but not to the degree that all of this is coming in my opinion.
Had 286 million page views.
Objection, Judge, is a fact witness, not expert relevance.
I'm not asking his
You know who
opinion.
Mr. Jones was.
Overruled. If he knows the answer, he knows on his own knowledge, and if he doesn't, he doesn't.
I didn't know that, sir.
See, he's asking about how much money they're claiming gross revenue that Jones made was. This is a classic version of unfairly prejudicial evidence, which, by the way, these numbers are completely mistake the nature of the business. So you have a business, you have a business which has massive overhead. So the gross revenues of all products sold include the cost of the product, the cost of delivery of the
shipping,
product,
but forget that. I mean, they're talking about impressions on social media as though 4 billion impressions is somehow representative of anything.
And how does asking this witness about InfoWars gross revenue have anything to do? Not only is it not within the competency of this witness, how does it have anything to do with the case, period? Again, how much money they made is also irrelevant at this stage. That was originally intended as evidence to prove actual malice. And even though courts have said generally it's not really relevant to actual malice, this court allowed it. And by the way, here again, we're seeing evidence of all the financials. What evidence was it that Alex Jones hid that supposedly was the grounds for default? You're going to see throughout this trial that Alex Jones didn't hide any evidence by the evidence the plaintiffs themselves put into the record.
But even if we Robert, even if we operate on the basis that he did, to the extent that thus far what we've seen was it was about identifying how many videos they posted and financials. None of that impacts the essence of the claim itself or prejudices the plaintiffs from making whatever evidence they needed. It's
correct. And especially at this stage where actual malice, as the plaintiff's lawyer made the clear point of, is not a question for the jury to determine. So how does what Alex Jones or InfoWars gross revenue was in any given year, how is that relevant to the emotional harm this individual suffered? It's classic unfairly prejudicial evidence.
9 million page views just in the month of December alone?
No, sir.
Now that you know he made how much money would you like to cash in on your crying in tears, Mr. Witness?
I do not have that as a exhibit.
That's, by the way, why I wouldn't ask that line of questions, even if I was the plaintiff counsel. I wouldn't highlight money, because that if you're playing into the stereotype of your own kid.
We have 286 by 289 by agreement.
I don't know, let me give you that. Say what? No objection, Judge.
Thank you. 286, please. Can you tell the jury, Bill, what's happening in this photograph?
Sir, that's me in the center with three of my other
Now,
teammates.
tell me that image
That's when we
doesn't
were
contradict
initially
the
arrived.
Stand.
At
You
least
know what I
I
mean?
believe it's when we
The image-
initially arrived and
see
we
that
we're
image,
coming
you
up
think,
the access
oh,
road
hold
to
on,
the school.
badass.
Sorry, go for it.
I'll say the image presents tough badass, shades, military equipment, big military equipment. But what you've got on the stand is someone who 10 years later can't handle emotionally describing pretty much anything he witnessed.
I'll say that a snap. He'll never be whatever. If he was faking something in that image, or if he snapped.
And
This guy's not.
if it was really decided on the facts, why would you as a plaintiff's lawyer not want to present this evidence? Because what you're highlighting is a guy who was already completely broken. What emotional damage could have Alex Jones caused when this guy was completely wiped out already?
Yeah, they'll say it aggravated the trauma. He saw this, it broke him as a human, and then he had to hear someone say that it didn't actually happen. I mean,
But how much does that add to the
That's-
quantum of?
well, especially
like if you already lost it, how much does being reminded that you've lost it? You know what I mean? In other words,
yeah, but they'll say
you suffered the most emotional damage that you almost possibly could.
Agreed. And he'll say, well, I got harassed by people who thought I was a fake FBI agent, whatever. And then the argument's going to be, well, then sue the people that harassed you instead of presupposing that they were doing it at the direction of Alex Jones, or if they were inspired by him. Then what are we getting into? People who get inspired by Howard Stern to do things. You're going to go sue Howard Stern for that? It's got to be a pretty direct causal link to do that.
Do you know whether this photo was later published by any media?
Yeah, that photo was
Everywhere.
I was on the front page of papers all over the country, from what I recall.
I just want to point out the jury, Bill. Do you see how your teammates here have their FBI insignia on their vest?
Yes, sir.
But you don't, right?
Correct.
And that's what you were referring to earlier when you were describing that you weren't able to get geared up because you were changing to a new vest. Is that right?
Yeah, I was taking the items off of this vest here and putting on a new one they had just issued me.
You see that the teammate to your right has what appear to be canisters or containers in that part of his vest. Do you see that? Do you know what these are?
They're ammo pouches, sir.
Did you have those on your vest?
Oh, sir.
Go to the next picture, please.
This would be 287, Your Honor.
You see yourself depicted here, Bill?
Yes.
And what's happening here?
Again, it's the vest that I had taken all the stuff off of, sir.
Why did
So just make sure you keep your.
It's the vest I had taken all the stuff off of, sir.
Also, you can pull out, please. Thanks.
Also that morning in Sandy Hook?
Yes, sir.
288, please. Similar to the photo we just saw earlier.
I think it's the same photo, but
Okay.
okay.
289.
Yes, sir, that's the photo that was on, I think, the Harvard Current.
Just-
This was on the Hartford.
I'm sorry.
That was, I'm sorry.
Just have to make sure that, everyone can.
Yes, Your Honor.
You said that at some point you were sent to an emergency management facility?
There's there's another school in Newtown, I don't know, a private school maybe, or like there's another school where they set up an emergency operations center, which is typical in crisis management. And so if you have a crisis, they'll set up essentially a headquarters to operate that crisis from.
And that's where you were stayed until you were discharged?
Yes, we drove to it. We met with our senior leader from New Haven. We met with her and for a briefing, and then they sent us home.
When you left the school that day, did you have to go back down to your vehicle, and did you see the firehouse?
Yes, I came down. Yes, sir.
Did you understand that parents and families have been asked to gather at the firehouse?
Yes.
Say a leading question, but I don't think it makes a difference at this point. Like they're gonna go through a day of this guy's testifying on his trauma. We have yet to get to anything related to any trauma Alex Jones might have caused him through his words.
After that day, did you return to Sandy Hook the following week or at some point soon thereafter?
Yeah,
Why?
I know within a
Didn't even
day or
answer the
so.
question yet.
Why?
There were threats being made, some type of threats to the children's funerals, that the people were going to come and cause trouble at the funerals. And so I
Now,
recall,
by the way,
Objection on hearsay, Judge?
I had never actually heard this either.
if he's going to
am
get
offering
into
for
the
the
fact
truth
that
matter.
the
Objection
belief
to
that
strike on
this
hearsay
was
grounds?
not a real event, the irony, what they would actually be proving, they're probably going to try to blur the line on this, is that the idea that this wasn't a real event didn't originate or come from Alex Jones at all. That in fact, of course, if you know the real story, as soon as Sandy Hook was politically weaponized within days for preaching gun control, and the Obama administration seized it right away. From that point forward, throughout the entire viral social media sphere, which this was when social media is starting to reach its real inflection point of influence, throughout on Facebook, YouTube, etc. All of a sudden, there was an explosion of videos, comments, posts claiming that the event wasn't real, making the crisis actor claim, all this other stuff. Nothing to do, though, with Alex Jones. Tens of millions of views of these various videos and posts being made over the time period before Alex Jones ever questioned whether Sandy Hook happened at all. And so what's irony is if he's saying, oh, you had to come back, they're probably going to try to misallocate blame for this on Alex Jones when Alex Jones had nothing to do with it. And my guess is the judge won't allow Alex Jones' defense to prove that point. But where he's going to is that the harassment was coming from people who had nothing to do with Alex Jones. We know that because Alex Jones hadn't questioned whether Sandy Hook happened at this point.
You can continue though.
and that's what we were briefed. We were briefed that this is that you'll be assigned to cover funerals. And there were a number of guys on the team that probably covered, they were there like 2 or 3 days, and I was there maybe 1 or 2 days.
And were you aware as part of your responsibilities with the FBI in a few days that the victims had been targeted for harassment?
Objection, leading.
Sustained.
I'll ask you again.
Yeah,
Yes, sir.
now that
Did
you
you
know,
become
now that
aware,
you know the answer, he wants you to give.
In the week or
Ask
so
again.
following the shooting, whether or not families have been targeted for harassment?
Yes.
How did you become aware of that?
I would have received that information through my either team leader or my supervisor. or
Again,
through
this
the
has
state-
nothing to do
through
with
the
Alex
state
Jones.
police.
None of it's
And in
it's
fact, the
obvious.
what this proves, by the way,
is that
the
Alex Jones
harassment-
wasn't responsible for the harassment.
Exactly. And
And
that's
were
the
you
little
part of a
secret
team
they've been
that
trying to
actually
keep
did
secret the whole time.
try and
Alex
provide
Jones
security
was
for one of
not
the funerals?
responsible
Yes, sir.
for this harassment. But the
Was that
judge will
Trinity
likely
Episcopal
not
Church?
allow Alex Jones to
Yes.
point that out, his defense to point that out. We'll see.
But he's already guilty, Robert. Inflicted
Exactly.
intentional.
Guilty until proven more
I'd
guilty.
like to move forward, Bill, into January now of 2013.
Yes, sir.
So we just went from the day of the event to
Prior
January.
to that time, I think you described it. What was your position at the FBI?
So in 2012, I would have been working out of the Meriden Resident Agency, which is part of New Haven Division, and I was working public corruption and civil rights matters.
So it looks like he might have
January,
stopped.
did you assume a new position?
I was put into a position they call Chief Division Counsel, which is the head attorney for that FBI division. You give legal counsel to the leadership of the division. I was put in that position temporarily, and then about a month later, I was appointed to that position.
So you were the
So after Sandy
top
Hook, he
lawyer
gets
providing
promoted to a
advice
prestige
to the
position
FBI
of political
Connecticut.
influence in the FBI.
In-house, yes, sir.
In-house.
Yes, sir.
And
That's how I read that, by the way.
in that capacity,
He
did
became
you
the
have any
local office version of
responsibility
James Comey.
for managing
James
the
Baker,
FBI's?
James Comey.
Say
So
that
James
again?
Baker was the counsel to Comey for the FBI, but the FBI at every level has lawyers who advise them. And he became to the local FBI office, he became what James Baker was to James Comey. But that's a position of great political power because of what issues flow through you. You basically get access to almost all the FBI's potential dirt. So it's a position of great political power. It's a promotion by almost any definition.
Response to complaints of threats, harassment, and other activity directed at the families of Sandy Hook.
So in the position I held, I had a number of people I supervised. And one of the programs I was responsible for was the Victim Services Program, Victim Witness Program. And so I supervised the victim specialists in New Haven.
She was part of your team.
She was on my team, yes, I was her supervisor.
And can you describe for the jury, beginning when you assumed that role of managing the FBI's, well, first of all, describe for the jury what your offices, including the victim specialist, what their role was in assisting the families after Sandy Hook.
I can tell you
This
on
is
the,
odd.
on
Why
the-
does the FBI have
day
victim assignments to the Sandy Hook case?
on that day, our
I didn't-
victim
To
specialist.
my knowledge, this
and a
was never
number
an
of
FBI
other
case, unless I missed
people
it.
were,
Again, maybe I
were
missed it.
there.
You see what I mean? This is not a normal FBI case. I didn't know this ever was an FBI case. That means there should be substantial FOIA that the FBI has on this case. I don't, maybe people have FOIA'd it and I just don't know about it. But to my knowledge, this was always a Connecticut state case under Connecticut state jurisdiction, never an FBI case. This is the first time, at least I'm hearing, that this was an FBI case, that there were FBI officials assigned, FBI lawyers assigned, FBI victim coordinators assigned. What was the federal case here? It's not clear to me there was one.
There to assist in various roles. So that's all our victim specialist did for, she is interacted with a number of the families and assisted them in a number of ways for months, if not, it was probably like 18 months after. It was,
Pause.
It was,
Name the school shooting that's been a federal case. I don't know of any, right?
What does it even? I mean, not like a
Uvalde's all being prosecuted by the state. Parkland's being prosecuted all by the state. Columbine is prosecuted by the state. All the shootings I know of were prosecuted by the state, right? Or I don't know if any of them are federal.
But what would it take to cross the jurisdiction from state to federal for a crime? It would take obviously a federal crime to have been committed.
Yeah, exactly. And here, I mean, he was dead. So it's not clear that there would, I mean, what federal case could there have been? And yet they're saying they had victim coordinators from the FBI assigned that all they did was manage the families, the issues related to the families, whether it was harassment or whatever else. So maybe the harassment angle was a potential federal crime.
Interstate harassment. I mean, I don't know how to phrase it, Robert. I'm not trying to be glibber or facetious.
Yeah, no. I mean, maybe that's the angle. It's whatever it is. The predicate has been skipped over here. He hasn't explained how the FBI ended up on the scene in the first place.
Let's see if Pattis gets the memo and asks the question if he can. Objection, relevance maintained. Here, let's do this again.
It was 99% of her work. That's all she did.
When you said she assisted them, what did she assist them with?
Objection, foundation, hearsay, relevance.
By the way, that's a good combination of objections for those people out there. Those are three different evidentiary predicates. Now, I like to cite the rule number because I'm not a big fan of speaking objections. Also, it tends to judges tend to like it because they don't think you're grandstanding or trying to say something to the jury. So you say Rule 401, Rule 402, Rule 403, Rule 806. But I like to do multiple ones, and that's what he did. There's like, okay, there's no foundation here. What does that mean? It means he's testifying about something he hasn't established his basis to know about. So like all this testimony is supposed to be from personal knowledge, and he's saying he hasn't established how he has personal knowledge about something. So that's the foundation objection. The relevance objection is it's not material to a damages trial, which to me, almost all of his testimony so far has been irrelevant. Even if it was, the only added objection I would make is the cumulative confusion prejudicial part.
Complaints.
And you managed her in fielding those complaints.
I managed her in fielding those complaints and then would direct it to the appropriate supervisors, depending on, and it was usually to the Bridgeport supervisor, because Newtown is covered by Bridgeport.
And were the families who lost children and loved ones at Sandy Hook directed to contact your team if they were experiencing harassing or threatening behavior?
To be honest, I'm not sure if they were directed to. I just know that the victim specialist had pretty close relationship with a number of the victims' families and also with a number of or at least a couple officers from Newtown.
You say 99% of what she did for 18 months was helping the families respond to complaints of threatening and harassing behavior directed towards them?
Yes, sir.
Describe that for the jury. And did that start
almost all
as soon as you took over as chief division counsel in January?
From what I...
So it was, all of this was happening before Alex Jones ever said anything that he's now being sued for.
They're accusing him the day of having said, they're coming for your guns. I think that was
right.
the statement
Correct.
he made
But that
it happened. It means it
right,
happened
exactly.
and they're going to use it.
So what he's being sued for everybody out there, is saying that Sandy Hook didn't happen. That's the core theory. Those statements don't happen until much longer after Sandy Hook happened. What they're describing here is that almost all the harassment began immediately after Sandy Hook, which means the harassment could not have been caused by statements Alex Jones had not made at that time.
Mm-hmm.
And but they're going to confuse the jury, and the court's allowing it and will likely continue to allow it because they wanted to build this fake story about, that's the irony. This is supposed to be a trial about fake news, but they're promoting a fake story as part of the actual trial, which is to blame Alex Jones for things he had nothing to do with, just because chronologically he couldn't have been.
I recall, yes, because I remember dealing. It was an awkward situation, right? Why is the division counsel supervising victim services? So I was new to it, and so I relied on her.
He just
heavily.
acknowledged how unusual what he was doing was.
Somewhat new herself, but she was awesome. She was very good, and I'm sorry. I interacted with her multiple times a day.
This stuff is going to increase conspiracy. The hardcore conspiracy theorists, now that this comes out, that the FBI counsel was micromanaging a good number of the family members and cops connected with other people, at least that could be the gist of his interpretation, will feed skeptics of what precisely happened, unfortunately. So, I mean, because I was unaware of it. I mean, so and to be honest with you, I don't see how any of this really serves the plaintiff's purpose. I get where they're trying to misallocate blame to Alex Jones, but only by getting away with that is any of this even possibly helpful, because it's mostly proves the point that Jones is not the source of any of the injury.
And it was Newtown all the time, and it was constant.
Describe, I mean, you call it constant, can you describe to the jury the general nature of the type of harassment and threatening behavior that was directed at these families?
It was
Hearsay, what did he see? Excuse me, objection, hearsay.
if I could tell,
That sir's repeating what someone else said, okay, so don't.
I can rephrase it, Your Honor, I can rephrase it. In carrying out your role, supervising the FBI's response to complaints of harassment and threatening behavior, was it crucial to you to understand the types of threats and harassment that these families were dealing with?
of course it was, absolutely.
And that informed your response to it?
That, yeah, of course. Yes, sir. Yes.
So can you describe for the jury, please, the types of threatening behavior and harassment that these families were suffering that you were called to respond to?
So,
Objection, Judge, can you describe the reports he received? He can't testify to the truth of the reports.
so
Objection.
Sustained.
Special Agent Aldenberg, I'm sorry, Bill. Tell the jury
I don't understand
the
it,
types
but
of reports
I'm going
that
to
you
stop
received,
commenting on that.
and that you, as the FBI, managing the FBI's
Special
response,
agent,
responded
sorry,
to.
Bill.
death threats, people calling all kinds of numbers in Newtown, saying that this is Adam Lanza. I'm going to come and kill you all. Telling people their children aren't dead, that they're actors. That's what I'm referring to all the time.
All of which was happening
Families
before
aren't
Alex
real.
Jones said anything.
The
Along
children
the
weren't
lines that he's being
real.
accused of here.
Death threats.
Jones was not the
and
source
serious
of the
stuff
harassment.
from seriously disturbed people.
And this went on for 18
Also there.
months with
Oh, it went on much longer than 18 months. It went on 18 months for that particular victim specialist because
And it started.
she ended up
early on.
transferring.
it continued on.
Continued. It's going to continue after today. Like, when
Objection, move to strike, speculative, non-responsive.
So I will,
it's not speculative.
Objection, move to strike.
I am going to sustain the objection and strike that answer.
It continued throughout the entire time you were Chief Division Counsel, didn't it, Bill?
It's been going on for 10 years.
In other words, independent of and separate from Alex Jones.
That's why it's an interesting thing. Like maybe Pattis doesn't object and let him answer it. 'cause
And during
he'll be
this
able to
time-
twist it or spin it. Sorry.
During this whole time, as a result of your supervision of the FBI's response to this type of stuff, did you become aware of who Alex Jones was?
Yes.
How?
Through conversations with the victim specialist.
And did you have an understanding at that time what the genesis of this type of behavior was?
Objection calls for hearsay at this point.
Can you,
Overruled.
can you clarify the
overruled.
question, sir?
See, here they're trying to
What was your
blame
understanding
Alex
as to
Jones for
Alex
something
Jones'
that isn't him.
role in creating this barrage?
That
Objection, hearsay.
Overruled.
my understanding at the time was that there was this person who had a radio show or an internet program that was saying that Sandy Hook never happened, that that we were crisis actors, and that the children and the families weren't real people, that they were crisis actors.
So did he actually go and watch any of the shows for that? Because Alex Jones didn't say that during the time frame he's talking about.
But and I'm just reading in the chat. Someone said I'm going to change my mind on this witness, not on his reaction, but now it's going to affect my assessment of his credibility.
There come a time, Bill,
as to what he's looking to blame that trauma on. He's looking to blame it
during
on
these years in
something,
which you were
and he's going to go with
involved
Alex.
in the FBI's response to this, in which you yourself became targeted.
Yes, sir.
He's angry, he's broken, he's
When was
traumatized,
that?
and he needs to find something to blame it on.
So I've thought about this a lot,
Mm-hmm.
especially lately, and there were key moments when I became aware of it. But I would say that somewhere from the spring to summer of 2015.
All right, may I have just one moment to get some water?
Certainly, take your
Go on,
time.
Jess. You said, Bill, that you first became targeted in spring, summer of 2015.
Spring, summer.
When I say targeted, you have an understanding what I mean?
Yes, sir.
Describe for the jury what that was.
That they basically had taken some of those photographs that you see, and tore it apart. That this guy's not a real FBI agent. He's not an FBI agent because he's not wearing an FBI logo. He doesn't have the right uniform on. He doesn't he doesn't match with the other agents.
The picture, which was all
he's
over
an
the front
actor.
page news as of the day of.
And let's just back up for a second, Bill, because there's got to be some way that you find out about this. How do you find out
So
about it?
I find out. What I remember is that I found out about it at work one day, and I came home, and I said to my wife, "There's something going on online, and I'm not really sure what it is." And literally, as I'm sitting my wife down at the table, not the table, the computer desk, so she could take a look at it, the oldest son, who would have been either a freshman in high school or going into his freshman year, he came through the door. He said, "Dad, there's stuff online. Kids are more attuned to that. At least certainly my kids were more attuned to what was going on online than I was." And he's like, "Dad, we got to come upstairs. You got to see this." And I said, I just said, "Well, whatever it is, we'll figure it out." And so that would be probably the first time. That would have been either again early spring or
They still haven't tied this to
summer
Alex
of
Jones.
2015.
And your son's name is William, like you.
Yes, sir.
So when Will comes and says to you, there's something going on online, and you kind of heard that something was going on online at the Bureau, did you yourself then try and figure out what is it that's happening?
So that I was pulling it all up, but it was essentially they were saying that Mr. Wheeler and I were the same person, and that comparing my photographs to Mr. Wheeler, that we were one and the same, and that was proof that one of the proofs that Sandy Hook never happened.
You and Mr. Wheeler, you're referring to David Wheeler.
Yes, sir.
David Wheeler, whose son Ben was killed at Sandy Hook.
Yes, sir. Yes, sir.
And there were photos of you next to Mr. Wheeler.
Yes, so they basically would superimpose our faces with arrows, and they were focused on parts
Again,
of
this
our,
is they.
or at least they were focused on parts, like they were focused on my earlobes. There was like videos. There were like hours-long videos about it.
Yes, and none of which were from Alex Jones. You're
Can
on
you
mute.
describe for the jury the volume of stuff you were seeing?
Yeah, hopefully Pattis is going to pick up on this
I can
and
only
put together a
describe it
timeline.
That,
The date of the allegedly well, they're not allegedly,
pull up
the defamatory statements.
and there'll usually be like 10 lines of things, like you Google
I'll be back in 1 second.
whatever the topic may be, and there's 10 entries, and then you could hit the next page. I could just tell you it went on for a page. It just went on. It went on, seemed like forever.
What was your reaction to this when you're seeing yourself all over over.
It's you can't even describe it. It's like, I don't even know how to, I don't know how to describe it. It's crushing. I mean, you're basically under attack and you can't even defend yourself.
What about it? I mean, I take it that you weren't a very online person.
No, I would not describe. I don't have social media or anything like that. I don't have social media myself, but people create social media accounts with my name and spread this filth.
But when you say that you felt under attack and defenseless, what is it about seeing this stuff online saying that you are an actor and that your experience at Sandy Hook was fake? What is it that was overwhelming to you?
It's one of the worst things that ever happened, if not the worst thing that ever happened here, right? What happened?
The worst.
And
worse
people
than
want to
death.
say this didn't happen, and then they want to get rich off of it. That's the worst part. Like, you know what? You can say whatever you want about me. I don't care. Just say whatever you
This
want.
guy,
I'm
I don't
big enough, big
believe
boy. I can take
anything
it.
from this guy.
They
This is
wanna-
such a
they wanna make
political,
profits. They
rhetorical,
wanna
what he's
make
doing right now,
millions of dollars. They wanna
grandstanding
destroy
professional
people's
witness. I'm sorry.
lives.
Like,
Their children.
maybe
got
he is all broken
slaughtered.
up, but now he's doing a
Sorry,
long
stuff.
closing
And now
argument.
they have to sit here and listen to me say this. And these people.
I'm sorry.
made
This
millions
now sounds
upon
like
millions
acting.
upon millions.
This
They
sounds like
destroyed
dramatic
everybody. They don't give a
performance
damn.
by him on the stand.
That's why. That's what's upsetting about it.
That part
And
I
then-
didn't
and
buy
they'll
as
make
authentic and
excuses.
original. That I
Hang on a
bought
second,
as
hang on a second.
that I listened to and I heard prepared. Too many prepared. Honestly, prepared too much. I wouldn't if I was
Since
my
2015
witnesses, I
until
wouldn't
now.
want that particular presentation. They're hoping the jury is the choir, and in Connecticut, it very well may be.
How have you dealt with these lies being on the internet? How have you dealt with that?
You just have to, I mean, at some point you have to just accept it. And
None of this as yet has been tied to Jones. You see how they
Alex
subtly
Jones
did
and
that?
his company, these
Like
are
he
very
does this whole,
powerful
I can't
people.
believe he
And
tied
I'm
in the
not
they,
anybody.
which he never tied to Jones, any of the videos, any
someone
of the
like-
exhibits, any of the images.
Like me, you just
But
can't
he said
defend
they
yourself. You
made
just have
money
to-
off of
At some
it.
point you have to
Connecting
accept
to the
it.
jury, the two are identical
And
when the
like
two are
any
not.
crisis that we all deal with in our lives, I guess you have to just, you just have to deal with it.
But how
The more
do
this
you
guy
do it?
talks, the
That's
less.
what I'm asking you is,
Maybe he's still traumatically just broken
What
up for
steps
everything.
did you
There's
take
aspects
in?
of him that are consistent
Well,
with that. The more he talks, the more I doubt that's the case. You know what I mean?
I caught the last part. No, but there's two separate things. There's if he's
Yeah, you're right.
he
You
was
gave
there,
one totally traumatic, broken up response,
and now he
political
wants
weaponization now.
he wants someone to pay for it, and there's only one person left who can or will pay for it, and that's Alex Jones. It's not it's not Lanza or his family. It's not the school. It's not the government. It's only one person that left to take the blame for this, and he wants it.
Right.
But
Yeah,
I tried to get help. I tried to get the Bureau to help me. And then, you know, I called the Agents Association to see if they could help me. And that ended up, you know, it didn't result in anything. They basically just gave me the runaround. And then finally, you know, the only person that ever even listened was Mr. Koskov. He was gentleman and gracious enough to listen to me, and that's why we're here.
Is there going to be a waiver? Objection relevance unless there's going to be a waiver of the attorney client.
I'll withdraw, Your Honor.
Move to strike.
It's interesting. He says the FBI didn't help him. Nobody helped him, and he needs to find someone to
Bill,
punish him.
what's,
Yep. And the plaintiff's lawyer
in addition to
is
the-
happy to help.
stuff online about you being an actor, have you received threats yourself?
Yes, sir.
Tell the jury
Again,
about
none
that.
of this, like I would have a
from probably
continuous
beginning
objection
in-
on some of this.
I can
None of
give
this
you
tied to
multiple
Alex
examples,
Jones
but
yet.
probably beginning in 2015, there was a guy from New London, Connecticut, who was so obsessed with Mr. Wheeler and I that he,
Objection to the characterization of the man. What did he see? What did he hear?
Sustained.
To the judge's credit, she stuck to the rules of evidence
You were
within
explaining
this aspect of the case.
nature of the threat that you received. You understood it to come from a gentleman in New London.
yes,
And what was the nature of the threat that was directed at you?
he went on for months, and he would call, along with others, would call my extension in New Haven and leave like violent, threatening messages. You're not Bill Aldenberg, you're David Wheeler. You're not an FBI agent. This guy from New London talked to a couple agents in New Haven who were so concerned about his behavior. They came and saw me and said, you really have to be careful. This guy sounds like he could do something. And Mr. Santiago, this guy's name was John Santiago, and his Facebook photo, you have a Facebook account and like a profile photo was.
Objection, hearsay. Have you seen it?
Yeah, I've seen it multiple
Objection,
times.
hearsay. Have you seen a document, not an evidence? Best evidence.
You personally seen it, haven't you?
Yes, sir.
Tell the jury what it is.
Objection, hearsay, best evidence.
It's a photograph on his Facebook account. There's a photograph of Mr. Wheeler's face and my face next to each other. That's his Facebook profile picture.
Did you become aware that this gentleman was connected to Wolfgang Halbig?
Yes.
Who's Wolfgang Halbig?
Wolfgang Halbig is an associate of Mr. Jones in InfoWars.
That's false. That's
Well,
completely
I
false.
don't know that.
How did I become aware of Halbig, or how did I become?
Halbig.
So Halbig was also one of the people that was writing harassing stuff about me and sending multiple emails and phone calls to the FBI, saying that I wasn't who the FBI said I was, or whoever.
And you become aware that you said that Mr. Halbig was associated with Mr. Jones.
Yeah, Mr. Halbig was on Mr. Jones's show.
Right. That's not association. That's not
You know whether Mr. Jones
InfoWars
supported
affiliation.
Halbig's
That's a
activities as
guess to
Connecticut?
get interviewed.
Objection, foundation.
I know that Mr. Halbig was on InfoWars spewing all this crap. And that Mr. Halbig was I know that he was in Newtown harassing people.
Did you know that Mr. Jones directed his audience to go to Mr. Halbig's website?
Objection, leading.
Did Mr. Jones direct his audience to Mr. Halbig's website?
To be honest, sir, I just don't recall that. I don't.
Because he probably never even checked out.
Do you know whether this
Well, enough said. It also makes the leading framing of the question even worse, given the answer that he gets when he asks it properly.
garbage about you and David Wheeler
Objection,
was on?
argumentative. Argumentative.
I don't think I'm arguing with Bill, so thanks. Do you know, Bill, whether this stuff
This
about
bill is just patently inappropriate
Mr. Wheeler
all the
and
way
you
through.
were-
And at one point, he accidentally said special agent, and he's like, "Oh, Bill." It's like he's doing it to get a response out of somebody. I can't figure it out.
Unless the court has for some reason allowed this. I mean, this is generally prohibited in court. You're not allowed to have a degree of familiarity or refer to someone by their first name. You have to by their last name and their formal designation, Mr., Mrs. Sometimes you can say doctor and special agent, etc. But generally it's supposed to be by their last name only. Not only that, it creates issues because you might have multiple people with the same first name.
On Halbig's website?
Yes.
Were they?
The stuff about me was on Halbig's website.
Notice he didn't
Now,
say it
Bill,
was
you
on
described a couple of examples of the type of threatening and harassing behavior. Fair to say that those are just examples of the countless types of things you've come
Objection,
across.
Judge.
Could you even try to calculate or quantify the number of threats and harassing behavior you've encountered?
It probably would be tough to quantify, sir.
Hmm?
It would probably be tough to give it a number, but it's it's significant, huge.
10, 100, 1,000, 100,
When you
1,000.
were advised
Can you give me
that
a
at
range?
least one of these hoaxers, in the FBI's estimation, you needed to look out for because he might do something.
Yes.
What did you understand that to mean?
The whispering, I think, is
He would
Pat's
either do harm
Jones's
to
attorney.
me or do harm to, my family or something. Or that's the way I
Just
understand.
because there's
If these people
often
are-
a mic at the council table. Sometimes you
Some
can
of these
turn it
people are
off.
very
Sometimes you can't,
deranged.
depending on the
And
court room you're in.
those,
But it's why you always have to be careful as a lawyer. Anything I always
the
tell clients,
defense will tell you, oh.
don't talk
you're
to me
okay.
until we're out of the courthouse if we can avoid it.
During the course of your time supervising the FBI's response to the hoax, complaints, and harassment, did you come to understand the size, even in general terms, of Mr. Jones's audience?
Foundation from whom, Judge? Foundation. I don't know if we're going to get any more into stuff from Mr. Koskov or not.
Did you come to learn that by virtue of your role at the FBI?
At some point, I came to learn the power and enormity of this whole InfoWars Alex Jones thing.
And what impact did the enormity of it have on your own feelings of security for yourself and your family?
So this
Like
is
I said,
a
I mean,
generic opinion about InfoWars
I've-
formed by what?
Had concern. I'm not worried about. I'm
Well,
not worried about
pause.
myself. I'm worried about my family. I mean, I could defend myself.
Hold on, sorry, I was
but my family
distracted.
can't defend themselves.
There is a strict protocol in place if any threat is made against an agent of the FBI. So when he said the FBI totally dismissed it, that suggests to me the FBI did not think these were credible threats. Just FYI. There's specific rules. The FBI is extremely protective of their own. That they'll arrest people in a heartbeat if you say anything that could be considered a actionable, credible threat. So that is an odd disparity in his story, as pointed out by our live chat at vivabarneslaw.locals.com.
Now, Robert, I might have to end this a little early today. So, what time do you have to go?
Whenever is fine. I'm flexible.
Okay, so I could maybe duck out and leave you solo, but then you wouldn't be able to pause it. But we'll go until I get summoned. Give me let's get back here.
And when I learned, really what InfoWars is and what Mr. Jones is, and the influence that Mr. Jones has, and I mean, he's affiliated with some very powerful people. I mean, I figured I was done. Just have to accept it.
Bill, after Sandy Hook, am I correct that you and your team members were provided counseling by the FBI?
Yeah, the 15th, the morning of the 15th, they made us go to, the FBI has a employee assistance program, the EAP program. They made us all go to EAP.
And did you continue to seek counseling as a result of the trauma that you suffered that day?
Yeah, the EAP person, the EAP lady that I've dealt with, it's probably the best thing that ever happened for me.
Did you also seek treatment to assist you in dealing with what you were suffering through as a result of the hoax, harassment, and threats?
So when I
Again,
got
that's
a real
not
grasp
classic
of this
This is an
conspiracy,
attempt to blame
or
Jones for anyone who
these lies,
questions
these
Sandy Hook when the two are
again,
not
the
connected
Pelbig,
in the manner they're presented.
Jones stuff. I went and saw. I hadn't seen the EAP lady in a while, but I went and saw her. Or she came to New Haven. I called her. I tried to explain to her what was going on, and she said, "Oh, I'll come up." She works out in New York, and she came up.
Why did you do that?
This whole thing is messed up. This is 10 years of, this is just awful. This is awful.
I believe him here.
Look what are we doing?
But what he's talking about
Right?
is the
We're
incident.
here to,
Objection at this point, Judge.
Bill, it's okay.
What are we doing? What are you doing here? It's
How
awful.
often do you Google yourself?
I check It depends, but probably like once a week I can look real quick to see if there's anything new.
Why do you do that?
Again, for the safety of my family. I'm very concerned about the safety of my family. These people, I mean, it's not an understatement to say that some of these people are deranged. They could be, when we walk out of the courthouse today, they could be outside the courthouse. These people are deranged.
Bill, so your understanding that the targeting of you, at least initially, was based on the fact that you didn't look like an FBI agent?
Yes, sir.
What about you were they saying didn't look like an FBI agent on the day you responded?
Again, it was all about the uniforms and weapons and how I was carrying my M4.
The day of, which implies that it had
You're having
nothing
a
to
hard time
do with
hearing.
Alex Jones.
So it was all about uniform, weapons, how I was carrying my M4, things like that.
And how did you feel when you learned that as a result of how you appeared, Mr. Wheeler had also been targeted?
But that's the worst part about this. I'm sorry. So the worst part about it, like he suffered enough, and then somehow, you feel like, geez,
I agree with you that it's the original incident.
maybe if I
triggers
at the range that day,
authentic trauma,
if I wasn't
and then
friggin'
and then the rest is misdirected
bullshit with
blame.
the guys as much, I would have got my stuff done, and then it would,
my read.
before all this happened. I don't know. You just like I absolutely take some responsibility that of what's happened to
But
Mr. Wheeler. If not,
Post-traumatic stress was so
it's not
severe.
right, man. It's not right.
He was
I'm
almost
sorry.
disability status by what he's describing.
Mhm.
If
Oh,
10 years
yeah.
later you can't control emotion in response to it, then that suggests SWAT team was wrong to support him.
You want to recess now, or
May we, Judge, please? Yeah.
beg your pardon?
May we, please?
That's fine.
Okay, so we'll take our 15-minute afternoon recess now. Mr. Farrar will collect your notepads and redistribute them. Continue, please, to obey the rules of juror conduct that I gave you. And we will start again promptly in 15 minutes, so please plan accordingly, all right?
All right. Let me see how far behind we are on the live here. Okay, so I think if I just skip to live, so we're not back live yet. Oh, 30 seconds left. Robert, how do you? I sent you the link. You could bring up the link so you could pause it on your end and stay live if I have to leave.
Oh, if you head out, we'll just head out for the day.
All right, and I think we're going to get the cross-examination.
We got the gist of what their theory of the case distilled through one witness. I would not have used the FBI guy. I mean, what's interesting to me is a traditional plaintiff's firm would have approached this differently. A traditional plaintiff's firm would have focused on the actual damages and the emotional trauma of the most sympathetic plaintiffs. They would not have made it such a political case had the FBI guy testify first, whose trauma is having people second guess whether he's FBI. And he's the weakest case by far, the weakest witness from a damages perspective by far. And both the opening statement and this guy makes clear how overtly political the case is, and it shows why the case never should have been defaulted, given the amount of discovery they have freely available to use in the court proceedings. And no one yet has been able to find me an analogous case. Not Nate the lawyer, not any of them. Find me one analogous case where a default judgment was issued where this much discovery was turned over. They can't seem to find it. Good luck with that. But the last component is how much between the opening statement and this, how much the whole case is really what Norm Pattis told him it was, the defense lawyer for Alex Jones. This is a case of them wanting to shut up Alex Jones, to remove him from the court of public opinion, from removing his rights of freedom of press and freedom of speech, and turning legitimate grief into a political weapon for impermissible purpose. And that's what we've seen with this witness, who has yet to even testify him actually hearing Alex Jones say anything, and is yet to even testify to seeing InfoWars publish anything. So what he said is these people harassed. The timeline doesn't overlap with Alex Jones's statements even. And his talking to the plaintiff's lawyer who told him to blame it all on Alex Jones. That's what we got from this witness.
Hey, you know, let's bring this back in for a second and just see how much I can get away with. How do I turn the volume on? Right here.
All right,
So it's going to be.
record will reflect that the entire panel is present. And that Mr. Floro
This
is.
is a 6-jury case with 4 alternates.
Okay, there we go. I'm back.
Thank you, Mr. Floro. Attorney Pattis, whenever you're ready for your cross.
And people, I'll post the link to Law and Crime in local so you can go.
Has to hit a switch to give us access. Thank you. Good afternoon, Attorney Oldenburg. How do I refer to you? I don't think I know you well enough to
Just
call
call
you
me.
Bill.
You can call me Bill, sir. It's all
May I
right.
call you Mr.?
It's fine, sir. Yes, sir.
Mr. Oldenburg, you've been an FBI agent for some time,
20 years, sir.
and you're trained as a lawyer,
Yes.
and you've testified, and you were a first responder. Well, withdrawn. Would you call yourself a first responder?
I would not call myself a first responder. I was part of a team that did like a secondary search. The officers from Newtown and the state police were the first responder.
But you arrived shortly thereafter and
Yes, sir.
provided assistance.
Yes, sir.
And some of the things that you saw there just are images that you cannot shake. Deeply
Correct.
disturbing.
Yes, sir. Yes, sir.
And I think you testified moments ago that in the wake of your response to the shooting at Sandy Hook, you were given access to an EAP, an employee assistance program person.
Yes, yes, sir.
What was that person's name?
That's Margaret Lane
And how many times did you see her when you were first referred to her?
for anywhere from probably six to a dozen, but dozen's probably high.
Okay, so somewhere between 6 and a dozen probably high. Were you seeing her once a week?
No. Every few months.
Okay, so every couple of months, would you call her or would she call you?
Both.
Okay, and you check in, how you doing? Are you coping okay?
Yeah, sometimes phone calls, sometimes in person.
And the phone call, and so among those 6 to 12 visits would be included phone calls, correct?
Yes, sir.
Some of them were very brief.
It probably, if it was brief, it'd be 10 minutes,
And if it was long?
See where he's going with
Maybe-
this. It's interesting.
20 or 30.
So did you ever see her in person?
Oh, yes, sir. I've met her multiple times in person.
Did you ever see her to talk about the trauma of what you'd seen at Sandy Hook on December 14th,
Yes, sir.
2012?
This is
How
known
long
as
would
my
those visits
style,
last?
too.
Again,
So they've
probably
called it
in
not
person.
what do you call it when it's like boom, 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 boom?
Yeah, rapid fire.
And there's another word, it's like an R word. It's like a certain kind of drum. I want to say ricotta for some reason, but I'm getting it wrong. Ricotta, or I'm blanking weirdly on the word, but it's boom, 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 boom. And it's because he's already got in his head where he wants to go, and he knows how to do it naturally. He's not operating off of a script. You're seeing an old school trial lawyer practice this. When people said, "Hey, why did he complain about all these other lawyers and these other cases?" It's because this should be the standard. You know, as you go up there, you ready? You know exactly where you're going. You know how you're gonna get there. You know it in your head. You don't have to rely on a script. You're able to react in live time to whatever he's doing. Notice he starts off with, everybody wants to, the other guy wants to call you Bill. I'm not so sure about Bill. So he makes that little point to the jury, but transitions into it. And he goes, let's use Mr. Let's stick with the formality. And then he's going with his sequence. And this is a professional witness. This is a guy who's been on the stand, as he said too many times to counter, some version thereof. He said lots and lots of times. So this is someone who's used to defense, and he's FBI. What does that mean? It means he's used to defense lawyers cross-examining him. It means he's going to be a very skilled, very tough witness to break. Now, one thing you're going to notice, just by the way Pattis is doing this rapid-fire questioning, you're seeing the witness motive tenor change. Note all of a sudden he's not momentarily breaking down every 5 seconds like he was on the plaintiff stand, right? And that's why I said, the more I watch this, I agree with you fundamentally. He was broken by the event. But there's more and more of this that I'm skeptical of the authenticity and originality of his emotive reactions. Just because here, notice how quick all of a sudden, boom, different time. But you achieve that in part by the style of questioning. Because the reason he's nervous as a witness, professional witness, he's like, okay, I got a hostile lawyer, Henry. He's trying to anticipate where the lawyer's going. He's trying to get there quicker than the lawyer can get there so he can answer the right way, quote unquote. But in order to do that, you have to change your emotive tenor as a witness. You forget that 9/10 of your testimony from a jury perspective is the emotive interpretation of your presentation. And just by shifting the style of questioning, Pattis has already changed this guy to looking a lot more like a professional witness than the broken man that he probably accurately and honestly is. And he's focused on the substance that he's getting into now. As the third analysis here is he's going to start highlighting exactly what the treatment was for and what it wasn't for.
Mm-hmm. Okay, let's see this.
30 minutes, maybe.
So is it fair to say you maybe spent 6-7 hours with her in the course of a couple years prior to 2015?
That may be a little high, but somewhere in that ballpark.
And then when did you first learn the name Alex Jones, sir?
When I'm assuming, I know I knew it when I was chief division counsel, so I assume I learned it from our victim specialist.
And when did you first learn that a man named Wolfgang Halbig had associated you with Mr. Wheeler?
I learned that, I may have learned that from this call center was maybe receiving calls, and someone from the New Haven division notified me that this guy, Halbig, was spreading these lies.
Was that the same person who informed you about Mr. Santiago, John Santiago?
No, so trying to think how I learned about Santiago. Santiago, I may have learned with a direct call to my extension.
Well, what you told us earlier is that you received calls and he would call along with others, be violent and threatening. You're not Wheeler, you're not an FBI agent. You talk to agents, you should do something about this. You need to be careful.
Right.
And that's how you learned Mr. Santiago, correct?
So wait for the next question, sir.
So was Mr. Santiago ever arrested?
No.
You are an FBI agent?
Right.
Responsible for enforcing federal law?
Yes.
It is a federal law to use interstate communication to threaten another person, correct?
Yes.
Was anyone ever arrested for threatening you online?
No.
He's drawing the inference there that I was.
How did you reach the conclusion?
If the evidence
that
was
Mr.
strong,
Halbig
if the threat was considered a legitimate threat, then arrest, what you can guarantee would have been made. And he's making the point, you're an FBI agent. Federal law is anybody makes a threat online over the phone to you, about you, concerning you, that's a federal crime that people get arrested and prosecuted for. Yet you're claiming these threats occurred and your own FBI, which you reported it to, never arrested anybody. And he's just leaving it there, right? Now, it's smart. The temptation of lawyers is to ask a why question. Ask a question that lets him volunteer something that might be hurtful. He's smart enough not to do that. Make the point, let it sit with the jury. Maybe this is a little overstated. Maybe these were all seen as kind of wackos doing wacky stuff, but not really serious threats. Otherwise, there would have been arrest.
Mm-hmm. Chat concurs, Robert.
An associate of Mr. Jones.
I watched, at some point I watched videos.
He's going to get him on the associate.
Of Mr. Halbig on Mr. Jones's show.
When's the first time you watched a video of Mr. Halbig on Mr. Jones's show?
I would be guessing, sir, I would say approximately like 2016.
Where were you when you saw that?
I was sitting in my office on the second floor at FBI New Haven.
You didn't file suit at that point in 2016?
No, at that point I couldn't get anybody to help me.
You were looking?
By then I'm pretty certain by 2016, I had contacted the Agents Association. I had been looking for people. I've been asking the U.S. Attorney's Office to help me. I'd been asking the FBI New Haven to help me. So yes, I was looking for help.
You mentioned that you tried after 2015. Well, I think what you told the jury this afternoon is, you know, you can say whatever you want about me. I can defend myself. I just accept it. You have to deal with it.
Right.
But you did find it emotionally distressing to be the target of this sort of publicity, correct?
Yes.
And you tried to get the Bureau to do something, correct?
Yeah, I've had multiple conversations with people from the Bureau, yes.
You said you told us this afternoon you tried to get the Bureau to do something and it wouldn't, correct?
I try to get the Agents Association to do something.
You said two things.
Okay.
You said you tried to get the Bureau, and then you said you tried to get the Agents
Yeah,
Association.
that's fair. Yes, sir.
And so is it fair to say that whatever
Pause.
you were bringing to the FBI in 2015,
Notice what else he stopped doing. He stopped looking at the jury. So two things here. Credit to Norm Pattis's style of questioning being so rapid fire that he is obsessed with anticipating the question, trying to protect himself. And he's so obsessed with it, his body language has gone away from communicating to the jury, and he's looking down, trying to have memory recall and chase in advance of where the questioning is going. And the emotive context has shifted. Also, he's being a little evasive. You know, 1 minute it's nobody will help me. I'm desperate for help. Well, maybe I went to the FBI. Maybe I didn't. Well, actually, nobody got arrested. You know, but supposedly these complaints were so serious, so credible, so severe, so substantial, so broad-based that it ruined my life. These are contradictions that Pattis is just quickly exposing.
15 and 2016, they didn't respond in a way that satisfied you, correct?
So they base it, as far as the FBI goes, no, there are individual people in the FBI that I'm thankful for the help they tried to give me. I could say it that way.
No arrests.
No.
Now, you mentioned you reached the conclusion that Helbig was an associate of Mr. Jones sometime in 2016 when you saw him on Mr. Jones's program.
Approximately 2016.
Could
Yes,
have been
sir.
2015.
It could have been, sir, but again, approximately 2016 is what I'd like to, is my answer.
Okay, could it have been as late as 17?
I don't think so.
Okay, so 15, probably 16 as you sit here today.
That's a guess.
Did you reach the conclusion that because he was on Jones's show, he was an associate of his?
I concluded he was an associate because he was spreading these lies about Sandy Hook and crisis actors. And Mr. Jones was spreading lies about Sandy Hook and crisis actors. So yes, I associated the two of them as they were on, because they were on the show together.
Well, that's different. Associating people together in your mind is different than making them associates. You would agree, correct?
Objection, Your Honor.
Sustained.
Look,
Just wait for the next question.
yes, Your Honor.
That was a fair question. What's the grounds to object to that?
When did you first
Legal
see a
conclusions
broadcast of Mr. Jones's?
That would have been when I watched it for the first time in my office in New Haven Division.
And would that have been at about the time you saw Helbig on the show?
Yes.
So prior to that, did you have, other than what you heard from the victim, and who was that victim's associate? You know, the person you were supervising. I don't remember.
The victim specialist was Ashley Hall.
Ashley Hall. So did Ashley
Yeah,
Hall
pause.
tell you about Alex Jones?
Here's another question. You have a bunch of FBI victim specialists assigned, as I understand from his testimony, taking up 99% of people's time for like 18 months or more. And yet no one was arrested. Isn't that odd? That's put it this way. The criticism of the handling of Sandy Hook was that it was being politically manipulated for a particular politicized purpose, away from the true cause of harm that took place and remedies that could preclude the probability of the recurrence of the harm in the future to others. And that the Obama administration had politically weaponized it, assigning a bunch of FBI and FBI victim coordinators and victim advocates to a case that the federal government is not prosecuting is very unusual and is consistent, at least, with the idea that they wanted to control the narrative in a particular manner that went to a certain direction. I mean, If you wanted evidence that this was being politically controlled to support only one narrative to come out of the case, evidence would be something like federal FBI victim coordinators working with the victims to make sure their focus didn't turn to something else, such as, say, the school safety inadequacy and things of that nature. I just find it very odd that there are all these victim coordinators out of the FBI's office for a case that, to my knowledge, there's no FBI prosecution concerning. At least this witness hasn't given any examples of that. Hasn't said this person was a victim because this person was arrested for this interstate harassment. I haven't heard that.
My paper is on it. I apologize.
I thought it was me.
No, it was me.
Okay, so maybe start the question over if you don't mind, 'cause I don't think her monitor got it.
Yes, ma'am. When did Ashley Hall first tell you that Alex Jones was talking about Sandy Hook?
I don't recall, sir. And you first asked me, was Ashley Hall the one that told you, and then you didn't let me answer that.
No, I think, okay, then please do. I'm not going to ever cut you off.
I have to assume in relation to the,
I can't let you assume.
Respectfully,
I'll withdraw the question and ask a different question. Did Ashley Hall first tell you about Alex?
I believe she was the one.
And when was that?
That would have been in the again, I was her supervisor from January 2013 to when she left.
The issue here, by the
New
way, is
Haven, which was sometime in June of 2014.
that was he knew about
You
the
didn't
state
seek out-
way outside the statute of limitations for bringing suit. And
Okay.
again, they've been just ignoring that. That's the other reason why they had to default Jones. They couldn't allow the statute of limitations defense to be presented on his behalf.
information on Mr. Jones from 2013 to 2014?
Can you clarify what you mean by seek out information?
Do I have to?
Well, do you mean, did I investigate him? Is that what you mean, sir?
No, I mean, Alex Jones is talking trash about where I was. Did you want to know who is this guy? What's he saying?
Sustained.
Did you take any steps to figure out who he was?
In 2014, sir?
2013, let's start there.
In 2013, 2014, I was not aware of stuff related specifically to me. What I was involved in is daily conversations at Ms. Hall about the harassment and the threats related to the families from Newtown, the victims' families.
And I'm sorry.
That's what I remember, sir.
And Mr. Jones' name came up in those discussions.
From what I recall, yes, sir.
Did you open an investigation of him?
I was not in an investigative position, sir. What I did is I forwarded any complaints to the appropriate supervisors.
Did anyone open an investigation
couldn't-
on Mr. Jones for engaging in interstate harassment?
I couldn't comment.
Sustained.
How is that not relevant? He's claiming Jones is responsible for all the harassment, yet the FBI never opened an investigation into it. Or they did, and they cleared him and said he wasn't responsible. Again, this is why the court's not allowing
That's a
Jones to
photograph of
present his
you,
defense.
Yes, sir.
flanked by two other agents.
They're task force officers.
These weren't guys on the SWAT team, I presume.
No, they were task force officers from Bridgeport.
Right. And so you mentioned that this photograph was distributed worldwide in the newspaper.
I don't know if it was that.
district residents.
Was this one of the photographs that was distributed worldwide?
I didn't say worldwide, but I'm not sure, sir. It's the other photograph, but I never said worldwide.
Okay. A person looking at that, how would they know you were an FBI agent?
Objection, Your Honor. Also
They-
speculation.
They wouldn't.
They wouldn't. And I don't want to drive too fine a point on it. I think what you told us earlier is when you learned, it was devastating for you to learn that people were associating you with Mr. Wheeler, a man who lost a child, correct?
Yes, sir.
And you take some responsibility for that association, you
Yes,
told us.
yes, I do.
You
Sir.
said maybe if I hadn't been, if I hadn't been BSing with the guys as much that day, I might have been able to get basically in your full gear, correct? The full regalia. You might have had your FBI patch on, correct?
Yes, sir.
Now, in 2015, this guy, John Santiago,
Just got my phone there with you. Ron, can you-
May I put it here, Judge?
Why don't you, Mr. Ferraro?
Sure. That's fine. If I turn it this way, it'll pick you up well.
Thank you, sir.
It's an unusual layout of the court to have the podium over to the side like that.
In 15 or 16, you learned about John Santiago, right?
Oh, that would have been in early 2016.
And at that point, did you reach out to the EAP program?
I believe that's somewhere around the Santiago and Halbig stuff and the Jones stuff is what I reached out to the EAP lady.
Santiago stuff, those were the calls that you were told about, correct? Where your fellow agent said,
Santiago's calls, Halbig's calls, and there were multiple.
oh, Helbig called you too?
Halbig called the FBI. I didn't speak to him.
Okay. How many times did Jones call you?
He didn't call me, sir.
Did you ever see this photograph 289 on InfoWars?
I didn't know, sir.
Do you know whether he ever talked about you on InfoWars?
I
Jones?
don't know.
There you
If
go,
Helbig appears
right
as
there.
a guest on a talk show, does that make him affiliated
Imagine
with the talk show?
that
To me,
three
it does.
questions sums it up.
Yep.
Jones
Yeah,
never
yeah.
called me. Jones never harassed me. No FBI case was open into Jones that he's aware of concerning harassment. Jones never published the photo. Jones never even talked about him ever. And yet he's suing for defamation.
Well,
Tell me this isn't insane.
Except, Robert, this might be my. Okay, I might have a few more minutes. No, but they're going to say that Halbig was on the show. That Jones was given
A guest.
No,
So
no,
there's a
listen,
guest,
listen. More
but
than
not
just
that he talked about him on InfoWars either.
no,
So if
but
a guest appears on your show and then somewhere else he goes and says something, the show now gets sued
well,
for
I mean,
something he didn't say on the show?
not just that, Robert. I mean, that would be the argument. They're going to say that it was more than a guest. He referred to, endorsed and made it look like he was supporting the message, and therefore, I mean, it's that's the argument you'd raise. But typically, you'd have a trial on it and not get a default verdict.
Well,
guilt.
and frankly, this would be dismissed. Look at the cases that are getting dismissed. The New York Times, Washington Post, NBC, major news networks, Taylor Lorenz, they're getting cases dismissed where they're the ones who lied. And yet here you have, hey, this other guy over here did something, and he listened to this other guy over there, and that guy over there was once on a TV show. So let's sue the TV show. This is never Nate the lawyer and the rest. Find me the precedent for this. Find me one. You won't.
Well, it'll be at least for this plaintiff. The other plaintiffs might have more direct statements.
They have other statements, but by the way, this shows you why it was a mistake by the plaintiffs to have this be the lead guy. Again, they started with their weakest evidence.
Okay. So if I appear on CNN tonight, I'm a CNN affiliate?
Yes, you are.
Okay.
Sustained.
How sustained? How
Yeah,
sustained?
exactly. There's no grounds to sustain that. Was that it?
It's a damn good
it's
cross-examination. Oh, there's a sidebar. Okay.
Yes, he wants his definition of an affiliate.
The default has established.
Plaintiff's lawyers panicking now.
Of course, because they want a one-sided presentation. It's, hey, judge, we get to present all our evidence, even though none of it's relevant to the case for the most part. Very little of it is, but they don't get to rebut our evidence because you've given them default judgment. So I mean, it's the same as Texas. It was egregious enough to give a default judgment, but they're allowing this show trial to continue, and I call it a show trial because they're allowing evidence that shouldn't be allowed in under their own rules, but they're only allowing one side to present their case.
These sidebars actually work out better for you folks because sometimes in trials, we have the jury get up, leave, come back, leave, come back. Like Mr. Ferraro so many times.
I wonder if
it's
the
like you're
jury
getting
can hear
your,
anything.
It steps in, so that's why the sidebars are a little more efficient, so just bear with us.
May I proceed?
You may.
Thank you, Judge. So when you went back to see the EAP person in around 2016, how many times did you talk to her on the phone in this period, 2016 and on?
2016, probably through just not too long ago, probably a few months ago. Again, dozen time.
Same kind of thing, sometimes 5-10 minutes, sometimes as much as half an hour.
I just remember when I first saw her I saw her in person in New Haven when all this stuff started up, and
Stuff.
all the lies from Halbig and Jones and everyone else. When all that started up, it was as if it was as if everything was coming back. I mean, to be honest, I was not that I was moving on, because I think about this every day of my life, okay? But I had it under control. And then this happened, and the lies and all that stuff. And I just remember being overwhelmed again, and that's when I saw her.
That picture was shown in 2013.
What's that, sir? I'm just pointing, like this stuff, sir. I'm just not pointing at the photo.
So
I'm
I
just,
looked at the photo.
yeah, it's just this stuff, sir.
I misinterpreted you. So in 2016, from 2016 to the present, you've spoken in EAP person maybe a dozen times,
That's fair, yes, sir.
maybe 6 hours
Total. It's hard to,
I'll be honest.
I wouldn't want to commit to
expected
number
him
of
to have
hours,
a
but that's fine. I mean,
professional
it's,
psychological. Say he's been seeing a shrink, go into details, daily basis, weekly basis, except that's your normal emotional distress damages claim.
Mm-hmm.
You say you've been seeing a psychologist, etc. Now, often plaintiffs don't like to get into that, because the problem is if you say, hey, my damage is emotional injury, then the other side is allowed to say, you know what, there's other causes for your emotional state, including other things that you may not want to be public, right? Personal issues, other issues. Usually you as a plaintiff open the door to those issues being fully disclosed when you put your mental state as an element of the case for certain kinds of not all, but certain kinds of emotional distress claims. So that may have also been a practical reason for them to limit the presentation of evidence here. But he didn't present a lot of, basically he's saying he talked to an FBI, my understanding of this, an FBI kind of counselor kind of person, a dozen times over several years for maybe anywhere from 10 to 30 minutes a pop. That doesn't sound like the kind of disabling emotional trauma that entitles you to millions of dollars.
No, well, he'll
not
say
not normally in America.
because it's interesting. It says that he wasn't getting that much therapy in the year or two right after the incident, but then this triggered all the trauma, and therefore it made it worse as of 2015. That's a double-edged sword.
And again, he tied Jones to everyone else, as if Jones is responsible for what everyone else did.
it's probably around that ballpark.
If it's more, just say so.
I mean, I've talked to her a lot. I've talked to her a lot in the last few years, so it probably is more than 6 hours.
Did you see in 2016 Hillary Clinton raised Sandy Hook and Alex Jones as part of her campaign?
Your Honor.
Sustained.
Did you watch any part of the Megyn Kelly interview in 2017?
Yes, sir.
Were you one of the people who petitioned local NBC affiliates?
Why are they
not to
so
show it?
scared of Hillary's speech?
Objection, Your Honor.
Bias, exaggeration, interest in the outcome.
Objection, Your Honor, and I think if this is gonna happen, we're gonna need.
All right, so I'm going to excuse the jury for this. The exercise that I told you about, you're now going to get, okay? So Ron will collect your notepads, and we shouldn't be more than a couple.
Actually, we should have to leave them in their seats.
Sure, even better. I'm going to give these to you.
Leave that in the seat. Please.
Fast forward through it.
Yeah, I'm just looking. Well, are they debating an objection here?
Please be seated. All right, so where are you going, Mr. Pattis?
As argued previously, it is argued that the defense opened the door to politics in this case by announcing that this was a case about stopping Alex Jones.
We're on cross now, right? So we have this witness on the stand, you're crossing them,
May
and
the
now,
witness be excused during argument so he doesn't know what the issues are?
certainly.
That's exactly the right way to do it. Too often they let the witness stay up there so they get to know where that's because Norm Pattis, this ain't his first rodeo.
Well, we would object to that. There's no sequestration.
All right, that's enough.
The
So
contention,
let me backtrack. So we have this witness on the stand. You're crossing the witness.
timing of this,
So tell me now what your issue is.
He's testified about how he became aware of Alex Jones, how he reached conclusions about an association of Paulding and Jones. And he's also brought a suit, his efforts to find lawyers to help him bring a suit. It's our contention that this issue was largely dead until Hillary Clinton made a campaign of issue of it in 2016, blaming Jones for Sandy Hook and associating.
Attorney Pattis, no, you may not, because I already ruled on the Clinton issue and we're moved on from that. So now you talked about Megyn Kelly. So let's address Megyn Kelly.
It's a similar issue to
Well, then stick with the Megyn Kelly, and I don't want to hear Hillary Clinton again. If
There you go.
want to
I don't want to hear Hillary
address
Clinton.
it,
You
you
can't
can
talk about
deal
Hillary
with
Clinton
Megyn
in this
Kelly
judge's
wherever
courthouse.
else you were
Whatever
going.
you do,
Clinton's
don't
been
talk
with
about
respect to
Hillary
Megyn
Clinton.
Kelly, given the nature of the argument that the plaintiffs made here, it's our contention we are entitled to put on exaggeration as a defense. If this man, when Megyn Kelly and NBC did an interview with Jones in 2017, a number of Connecticut residents petitioned local affiliates to not air the 2017 interview with Jones. I want to know if this man is one of them.
That's a fair point.
Attorney Matty.
Your Honor, number one, first of all, Attorney Pattis has no good faith basis for asking the question, even if it were relevant.
Good faith?
Mr. Oliver has been deposed. There's no evidence of any kind in this part. But the larger issue here, which is what Attorney Pattis is trying to inject in this case, is some sort of echo of what he made the centerpiece of his opening, which is that this lawsuit is an effort to silence Mr. Jones. And he was trying to get into Mr. Alkenberg.
That's exactly
that some
what
unnamed
he
That's what he said. That's what he said.
Lawyer said.
A letter to NBC for one specific purpose, and that is to try and inject some sort of political argument to the jury, which is impermissible and which we objected to in opening, and which we're going to want to be heard about more broadly. The idea that somehow Mr. Jones is being silenced, that members of the jury themselves should be able to listen to what they want to listen to, all of which touch on the First Amendment issues that are foreclosed in this case. And so this is just what we anticipate to be step one in this trial strategy, which is designed to politicize this case, to try and inject political issues in the case that have no bearing and that are foreclosed by the default. And so this is, I think, a larger issue that we're going to be dealing with. The Megyn Kelly one is
Proximate
easy,
cause
but
is
the
not
reason I raised it and I
foreclosed.
asked the jury to be excused is because we're seeing it come up again during the opening. Judge, when I asked for a curative instruction, you said that we're going to move on, but I can see it again, I will issue a curative instruction. This is what's happening now.
All right.
Judge,
Do you want to respond briefly on the Megyn
Yes.
Kelly issue before I rule?
Because I'm not the one who told the jury in a hearing in damages, stop Alex Jones, stop the bullies, speak out on behalf of the community, and didn't even raise in a hearing in damages for 35 minutes the question of damages, and then said nothing about it. The plaintiffs have made this case into a political broadside. I understand the court's causation, and I've carefully crafted my trial strategy around it. However, when these folks, the issue for the jury at this point is the extent of harm that Jones caused them. And if, in our defenses, these people are exaggerating largely for political reasons. And Mr. Manny can laugh all he likes, but it's true. They waited until 2018 to file a suit over 5- and 6-year-old claims, and they all appeared in Koskov's office miraculously, 15 people the same day.
This is a
Attorney
show.
Pattis. Attorney
It is.
Pattis.
I'm gonna,
Attorney Pattis.
I just need to
Like,
respond.
no.
It's not in front of the jury. There's no
No.
real prejudice to the
Objection
show that
is
Pattis just put on.
But Your Honor, on the larger issue, because who knows what his next question is
Well,
going to be.
why don't we address that
All right.
now so that we don't get the jury upset moving them in and out a million times? Is there some,
You've told me I can't ask about Megyn Kelly. I'm not going to.
I would,
I'm not going to.
okay, I understand, well, of course you're
Now,
not.
what's your next question?
So I'm not going to give.
Well, we did the Hillary Clinton, now we did the Megyn Kelly. Should we address what's coming next?
No.
Oh, I like him.
Well, I think it might make sense.
She wants
Judge,
to vet his
I'm not-
questions.
I'm not responsible for giving my adversaries a preview of what's to come any more than apparently they were responsible for telling me what witnesses they were going to call.
Unapologetic. He's
I
unapologetic.
understand your ruling. This has been a contentious trial. I am not going to be crosshairs with you on the first day or second or 15th day of trial. I understand your ruling. I will move on.
I like him.
I
It's
would just say,
Robert.
let's move on carefully. because
Understood.
By the way,
Ooh.
I
we're
was
not
the one
gonna
who
have
brought
jury
Jordan
jumping up
Patterson
and down a
into
million
it. So
times.
full disclosure.
I know why
Okay.
you like him, Robert. As you
That's
say,
why you
drop
have
it.
to stand up to judges or they will abuse you and beat you up. And you can stand up to them within the rules, within the proper code of conduct, all the rest, but you have to stand up to them. Otherwise, they will smack you around.
That was. You
That's
see her.
a classic case of how you stand up to a judge.
She's deflated. She can't reprimand him in advance.
And she's used to lawyers capitulating. She's used to lawyers cowering. She doesn't even know how to. Now, Pattis has been before, so she knows who he is. But she's probably just thought she could cower him into it, and is annoyed that she couldn't. He's also establishing things that she realizes look bad for the record. He said, "You said I can't ask anything about Hillary Clinton. I can't ask anything about Megyn Kelly." He's establishing that in the record. If she was smart, she would have pulled back her ruling. She didn't because she's not
All
smart
right, so
enough to know
this
how to
time you
handle it.
have to take the same seats because you've got to hook up with your notebooks, all right?
We are. I'm reading the chat. We're obviously gonna clip that because that is a paradigm example of what Robert has been talking about for years. Her hand on her
Council will
mouth.
stipulate that the entire panel is present.
I do, yes.
All right, please be seated. Whenever you're ready, Attorney Pattis, you may continue.
Thank you, Judge. Other than the EAP person, have you sought counseling from anyone else as a result of what you observed on December 14th, 2012?
No, sir.
Other than the EAP person that you've mentioned, have you sought counseling from anyone else over the distressing association of your image with Mr. Wheeler?
No, sir.
Okay. There are some courts that wouldn't allow him to present an emotional distress claim under these. By the way,
I have one moment, Judge.
Take your time.
he would
please.
say he doesn't have independent professional expertise.
Who are the powerful people that Mr. Jones is affiliated with?
Mr. Agent of the FBI, Mr. FBI lawyer.
He's
Donald
had-
Trump. He's gonna say Donald Trump. He has to.
I'm
He
sorry.
doesn't
He's
want to.
He, like, for example, he's on, I don't know if you know who a guy named Joe Rogan is. He's a podcaster, a guy named Joe Rogan.
Joe Rogan harassing you too?
No, not at all. No, I'm just saying, like, if I can answer the question.
If he can answer the question instead of being cut off.
He's not
I
gonna
could-
cut
I
off.
could-
He's other than Joe
No,
Rogan.
no, just one second, gentlemen.
Who's
All right, why don't we,
But
what, no. I now lost the question because I.
Let me
couldn't
rephrase
The
hear.
question was Joe Rogan.
I'll withdraw it and ask another.
Okay.
No, wait a second.
No, that's all right. So why don't we,
Guess he doesn't like
By
the
the way,
answer.
a
No.
remedy
Alright,
you can always
so
do to an
counsel-
objection
let's just.
is you simply withdraw
Sure.
the question and ask
Who are
a
the
different one.
powerful people
That ends the objection.
that Mr. Jones is affiliated with?
Well, that was
Joe
asked and
Rogan.
answered. That
You
was
mentioned
Mr.
Joe Rogan, that's
Rogan.
why-
No, counsel sidebar.
The judge is losing her control. She can't. She's so badly tempered. You're seeing
Well,
who
first of
this judge really is. She's so badly tempered, she can't even keep control of her own temper. The point of a judicial temperament is that people with a bad temper like this rogue
My
judge
understanding.
should not be on the bench. And every conservative, Megyn Kelly and others, that have apologized and excused these travesties of injustice in the Alex Jones case should be embarrassed by the fact they're vouching for these jokes of judges.
May I be heard, please?
Absolutely not.
Not even allowing Pattis to be heard. What a joke of a judge. What a disgrace to judge. The Connecticut court system is on trial, and its verdict is guilty, guilty,
You
guilty.
believe Mr. Jones
terms
is
of due
associated with
process
other
and justice in
powerful
this
people
case.
other than Mr. Rogan?
So just we pause because it's fascinating. He said, "What powerful people is Alex Jones associated with?" And he says, "You know, Joe Rogan." Then he said, "Is Joe Rogan harassing you?" They said, "Objection. Withdraw the question." What other people? Then the judge calls him for the angry sidebar, and he's getting the question back in afterwards, nonetheless.
Yeah, I mean, he has people on the show. I mean, he has, like, yes, he has people on his show, which I mean, I might think of anyone in particular right now. No, sir. I mean,
Nothing further.
Redirect?
No, I don't know if he's going to want to. Wow. Okay, Pattis has got.
Cojones.
I was going to say he doesn't give a bleep. Like that's when he's
But
looking
you
at
have
the
to.
judge.
You have to stand up for your client and stand up for the cause and not be scared of corrupt, rogue, intimidating disgrace of a judges like this judge.
Just briefly.
And what I mean by corrupt is not honoring the principles of law, but allowing personal or partisan or political prejudice to influence it. I'm not talking quid pro quo or anything like that. What I mean by corruption is not applying the rule of law because you have a personal or political or partisan or other prejudice that should not be guiding and governing your conduct in a courtroom. And you're seeing it in the lack of temperament. I mean, there's actually, I mean, what do we call it? The judicial temperament.
No,
What does that mean? It means someone who doesn't react like that on the bench.
She threw her pen down on the table. I mean, it wasn't even that bad. Everyone's seen
Over
worse.
Joe Rogan associate question. They just exposed what a fraud he was, trying to pretend. And what it was is, your point is exactly right. He doesn't want to say Alex Jones is associated with Donald Trump because that exposes the political prejudice he has in pursuing the case.
That's where I'm inclined to say he's a professional witness in that he knows that he doesn't want to give that answer. Joe Rogan, apolitical to some extent, but you mentioned Donald Trump because that's the number one answer. Alex Jones is associated with Donald Trump. That's number one answer. She threw her pen down on the table.
Bill, you testified that you saw Mr. Halbig appear on Mr. Jones's show, right?
Yes.
And I think you said that you may have first seen that sometime around 2016. You weren't sure?
Well, I'm sure that it's going to be sometime after April of 2015. And the reason I know that is clear as day, I watched the videos in my second floor office in New Haven, and I was no longer the chief division counsel. I was in a different position. So I know I was sitting in that office, and I wouldn't have been in that office until April of 2015.
And I take it that you don't know whether it was a live broadcast or something that Mr. Jones had posted to his website of a prior broadcast.
Oh, no, it wasn't live. I Googled it.
Can you pull up Exhibit 19I, please? Your Honor, this is admitted as a broadcast of Mr. Jones's on September 24th, 2014.
No, there's been no presentation during this witness's testimony of a statement by Alex Jones. Isn't that extraordinary? Defamation case. Lead witness. They don't have any evidence of any statement by Alex Jones concerning this witness at all. And he admitted on cross no such statement even exists.
And the clip is 19I. So 19 is already in. This is 19I. I think we're having trouble getting some volume. Thank you, Pratika. It's a big wind up here.
People will not give me a hard time when I have when Barnesy and I have technical glitches on.
Oh yeah, wait till you see it work.
We'll do this some other time. That's just fine. Bill, thank you very much. I don't have anything further. Thank you, Your Honor.
Thank you, Bill. Thank you, Bill.
You may
That
say
kind of
something,
makes
sir.
stuff
Just
look
watch your
lame.
step, okay?
Yes, sure. Thank you.
Wow, well, that didn't. I mean, look, it's amazing because this would have been a bad.
Do we need a minute to get your equipment ready to go for the next witness, or?
Thank you.
This would have been a bad cross-examination on the
We can
merits,
take a 5-minute recess if we need to.
let alone on.
I always welcome a bathroom break.
Our apologies. Thank you, Your Honor.
That's no problem. So we'll take a 5-minute recess.
All right, and this might be a good time, Robert, for us to.
Check
It's
out
gonna
for
go.
the day.
Yeah, it's going to go on until 5 o'clock. You guys can go watch and. From what let me put it on pause here. I can hear it, and let me go here. Okay, I'll tell you something. Like this will be inspirational for anybody who wants to, because Robert, I should say, Bob. I still don't even call you Bob.
Hey, Bobby. Well, the lunatic lawyer and the plaintiff's lawyer in Texas jumps up and down and calls me Bobby Barnes. That nut job. So
we've heard you. Like I posted the once upon a time the vlog where you were pleading the Covington kids on appeal. We heard you. Your pleading is fantastic. We haven't seen you go,
You got an example with Pattis. Pattis' style is basically my style, about 85% overlap between the two of us. It's from long experience in difficult underdog cases. So Pattis does civil rights cases and criminal defense cases. So when you do that combination of work, you're used to, and your Norm, to his credit, is an old school. This is why I brought him in initially. That, this was someone that could reinvigorate the old left civil rights aspect and approach to this case. The media has hated him for taking on this case, but you're seeing a skilled oral opening statement. You're seeing skilled cross-examination. You're seeing skilled interaction with a rogue judge. When you have a judge that's gone rogue like this, you have to stand up. And you saw how nuts it drove her, such that the next objection, she lost her mind and lost her temper in front of the entire jury.
And it's amazing. Hold on, I'm way out of frame. It was amazing where he says, let me give me your next question. You were just talking about Megyn Kelly. What's your next? No, thank you. I'll move on. You said move on. I'll move on. And he did move on. He did move on and didn't say, okay, what about another name, where he knows that she would have been validated in demanding that she pre-vet his questions. He said no, moved, and then I just love the way, like, he looked at her like, I don't give a bleep. I don't know how people do that. I'm too insecure, too nervous. We're like, my dad.
Most lawyers capitulate to judicial intimidation. It's why the judges like to intimidate, and you have to just be nope. Got to stick within my rights. Got to stick within my advocacy. Sorry, judge, no go. And the smart judges will learn to respect that. The less than smart judges will lose their cool, but that creates good appellate record for you on appeal. When you've got a rogue judge like this, you got to stand up for your client and the cause and your case and your advocacy, and you can't be intimidated, and you have to make sure the world knows on the record who these people are. And that's what we saw. Everything I previewed about this case, people saw on the very first day. It's a politically motivated, weaponized case. Many of the storyline they've heard is a fake storyline that the media has spread about the case. The supposed case about fake news, the case itself is often fake news. Here's someone that their lead witness is someone who didn't suffer anybody that died in the case, is an FBI agent who had presented one way on direct and a radically different emotional tenor on cross-examination. Who admitted that, in fact, they didn't even reference a single word that Alex Jones said that he ever read or witnessed or saw, and admitted that he knew of no such statement concerning him ever made by Alex Jones, and yet he's being allowed to sue under 8 different theories of libel law. If this doesn't show what this just today, you could watch this case and know what it's all about, know that the default judgment was a fraud based on a lie, that Alex Jones didn't participate in discovery. You can look at all the documents, all the financial information, all the text referenced in opening statement, referenced in the examination of this witness in terms of gross revenues, and know that part's a lie. Know the judge lacks judicious temperament and is very one-sided in her approach to the case at what theories of prosecution or defense she's allowing, very one-sided in that presentation, unable to even control her temper in the process, sustaining objections without grounds even being listed or itemized, often without grounds being available, period. And Pattis exposing what it's a political weaponized case. It's a case to try to convert grief from a trauma into a political weapon to stop Alex Jones from ever having freedom of press or freedom of speech, and then use it as a precedent against the rest of us. As Norm Pattis finished his opening statement, first Alex Jones, who's next?
I was about to say one thing about Pattis. Oh no, what I love also, speaking strategically, is he frames it as though he almost doesn't like his own client. He's like, what do you do if you hear something you don't like? We turn it off. I forget exactly how he said it, but he's framing it where, like, I don't like this guy, but I stand up for what he has to say, and it doesn't mean.
It's a perfect combination. He said, look, if you don't like him, you can just turn it off, tune it out. And there's a lot of stuff that you probably think is crazy when you hear this. But maybe sometimes he's the canary in the coal mine we need to hear about unusual risk. So he summarized who Alex Jones was. He put it in the political context that's correct, and that many of the jurors will relate to some version or variation thereof. And that this is a case about asking them to weaponize the legal system to suppress dissident speech and only allow the institutional narrative to be heard and listened to, which ultimately is about our right to pick what we listen to. So he summarized the case very well, succinctly and directly. And then the plaintiffs, in their own indirect way, exposed their own motivations and intentions about the case.
And I'll just end it by reading a few Rumble rants, because Winning Reality with a $50 Rumble rant said, hop, come and do the kangaroo hop. Hop, that's the dance for me and you. If you're over 80, you can waltz a little while, but hopping about the parlor is the very latest style. Come on and hop. And I think that's a kangaroo court reference. The Winning Reality had another follow-up. Don't care if it matters, nor now or who listens. I saw first the real disinfo about Sandy Hook came from Facebook groups that hated Jones, not inspired by him.
That's exactly right. In other words, the people that were saying Sandy Hook didn't happen originated by people who didn't like Jones. And in fact, most of that community that continues to believe it to this day, as the witness admitted, actually are anti-Jones. In fact, they accused Alex Jones of really being Beau Bridges, that Alex Jones died years ago, so on and so forth.
And we got a $5 Tropical Rocket says, this is one of the few conspiracies I did not hear about on InfoWars first. And
Correct.
Michael Swade says, Ben Swan reporting Lindsey Graham said they are going to create a licensing body for social media companies and require licensing.
Of course they want that to occur, but that should not occur. That's a bad idea, period.
All right. But Robert, we'll do this. I mean, we may not do this every day because it's going to be.
Yeah, it'll depend on the day. It'll depend on whether submit. But this was a really good summation. Today you got to figure out what the Alex Jones case is really about. And anybody thought I was exaggerating saw that I am not, about what this case is about, what the plaintiff's lawyers are about, what the judge is about. They got to see it in live time. But also for the people who could care less about the case, who want to learn how do you stand up for a underdog, disliked party against a hostile, intimidating rogue judge. You got to see an example of that. How do you deal with constant interruptions and interference based on bogus grounds with questionable objections? You got to see that. How do you deal with a witness who's one of the most sophisticated, prepared witnesses? Probably the reason they put him up first. He's been a professional witness much of his life as an FBI guy, as he himself admitted, testified too many times to count, or some variation thereof. You got to see how he got effectively taken apart, both in emotional substance and substantive content. You got to see how do you get stuff into evidence and stuff before a jury when the court's trying to preclude that evidence from being allowed to the jury when it should be allowed to the jury. You got how you maintain your own emotional equilibrium when you got all this hostility coming at you with constantly, simply for doing your professional duty. This was an excellent display by Norm Pattis of how you defend politically disfavored political dissidents in a court that's hostile and adversarial. How you do direct, how you do cross, how you do opening statement, how you interacted with a judge on motions, and including on sidebars. Excellently done all the way across the board. This is the first case I've seen of a lawyer, in my view, living up to quality advocacy in a courtroom. There's been little bits and pieces here and there of the other cases we've tried, but this was a distilled version from beginning to end of exactly how you do it. And so I recommend it as just a masterclass in learning trial advocacy. Watch Norm Pattis and what he did today.
All right. Awesome. And are you doing a Bourbon with Barnes tonight?
Yes, I will be live tonight at 9 p.m. Eastern time at vivabarneslaw.locals.com, answering questions live with Bourbon with Barnes. And so we'll have some fun.
All right. Awesome. Everybody, we'll see if we do this tomorrow. One way or another, there will be a live stream tomorrow. It's just a
we'll be
question
hopping in and out, of the trial where something's interesting happening to keep. Today just ended up being a perfect distillation of what it is we were looking for.
Fantastic. Robert, stick around. We'll say our proper goodbyes. Everyone in the chat. Oh, and I've been told on Rumble that I should wait a few seconds before ending it because there's a little bit of a lag before they stop recording. So let's just stare at us for 5 seconds, shall we? I'm joking.